All right, ready to start?
This meeting is being recorded.
Okay. Good morning, everyone. Welcome to the Board of Registered Nursing Board meeting. It is March 24th, 2022, and we will take roll call to establish a quorum. My name is Dolores Trujillo. I am the president of the BRN, and I was appointed by Governor Newsom in the direct care provider role. Vice President Mary Fagan.
Good morning. I'm Mary Fagan, Vice President, and I have been appointed by Governor Newsom in the Nursing Services Administration role.
Thank you, Mary. Elizabeth Woods.
Elizabeth Woods, present. I was appointed by Governor Brown, and I chair the Nursing Practice Committee.
I'm Dolores. Betty, can we work with your audio a little bit? We're still not able to hear you well.
All right. Can you hear me better now?
Slightly, not a whole lot.
I'm not sure what to do.
Oh, perfect.
That is perfect. Whatever you just did worked.
I didn't do anything.
That it's just a matter of how close you are to your microphone. I think when you lean back, so your voice drops off. That would be my guess.
Yeah, thank you. I don't have to repeat it all, right? You heard most of it. Do you want me to repeat what I said or not?
Yes, please. Yes, Betty.
Okay. Elizabeth Woods, present. I was appointed by Governor Brown, actually, in nursing practice, advanced practice. So thank you.
Thank you, Betty. Imelda Seha-Bukowitz.
Imelda Seha-Bukowitz, appointed by the governor in the public row. Thank you.
Jovita Dominguez.
Dominguez, appointed by Governor Newsom and chair of the Education and Licensing.
Thank you, Jovita. Susan Naranjo.
Appointed by Speaker Rendon, public member.
Thank you, Susan. And Tricia Nguyen.
Present. Tricia Nguyen, appointed by Governor Newsom as a public member.
Thank you. And our executive officer, Loretta Melby.
Melby or Lori, and I am the board's executive officer appointed by the board.
And our legal board counsel, Reza.
Good morning, everybody. Reza Pezhuhesh, BRN Legal Counsel.
All right, thank you. Moving on, BRN moderator, can we open it up for comments not on the agenda, please? And format of a teleconference call.
The BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I need to add something to this. We are on a different version of WebEx now, and we have the ability to translate different languages. If you would like to make your comment in a different language, please state so in your request for comment. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the board. Such inquiries submitted using this feature will not be answered. When asking a question, please make sure the question is directed at the host, me, in the dropdown. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when board members or senior staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief friendly reminder. To those on a computer platform, not sure how it's going to work on the phone platform. In the bottom left-hand corner of your screen, you are able to change the language to the language that you want to be translated to. I control the spoken language, so that's why it's imperative that you state that you would like to speak in a different language if you would like to make a comment. On the listening side, or actually, I'm sorry, on the reading caption side, everyone watching, you would then change your your caption language to the language that's going to be spoken, and it will translate it for you. Hopefully I made that clear, and thank you. We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, you may. Thank you. Okay, item 4.0, discussion and possible action regarding public comments received and adoption of regulatory language for California Code of Regulations, Title 16, Section 1427, clinical facilities. Is this you, Lori?
We have Heather Hoganson. Heather is
Okay.
the board's regulatory counsel. She's
Great.
not on the panel, I see. So unless Lori wants to jump in, I think Heather would take it from here.
Thank you.
Take it, Reza. Thank you. Yes, I was going to redirect her back to Heather as well. Thank you.
Good morning. Can you hear me okay?
Good morning, Heather.
Great. So item 4 is section 1427. As you may recall, we went out for public comment on this regulatory package in October, November. This went the same time as 3 other packages. So there is a comment that we received in your board materials. It covered multiple packages. We are looking at the comments directed to section 1427 this morning, and we'll be handling the comments directed to other packages separately at a different board meeting. Staff has reviewed the comment and does not recommend any changes based on the reasons listed in your meeting materials, and recommends that you vote to approve and adopt the text as it was noticed last fall. And unless you have any additional information that you would like to provide for us to put as a response to comments that we will compile for the rulemaking file, we are more than happy to hear any additional comments you might have.
Heather, this is Reza. Can you just briefly just remind the board and the public the process-wise about where this comment fits in and our duties?
Sure. So we went out for a 45-day public comment, and anyone who submits a public comment has that comment summarized and responded to in the final statement of reasons. That response comes from the board. With this particular feedback that we received, it was from the California Hospital Association and they had a number of changes to multiple packages. For this particular package, they wanted the number of students approved in a clinical facility program not to have what they considered minor or trivial changes reported. Staff's response to this is that we need to know everything based on the duties that BRN has in dealing with clinical programs, and specifically recently AB 1015, which was chaptered this fall on October 6th, added Business and Professions Code section 2717. And that requires the board to incorporate regional forecasts into the biennial analysis. And therefore, this information is very important to have about the amount of students in a clinical program and the clinical program size, etc. So this is a reporting requirement that not everyone wants to report to, but we think it's important.
Thank you, Heather. Any questions or comments from the board? I would like to make a motion that we accept the Reza, can I make a motion to accept the regulations as it is currently written?
Dolores, there is motion language. It would be on the next slide. So we just need to advance the slide to show you what the proposed motion.
Great. Thank you.
Right, the proposed motion would be to adopt the language as it was noticed back in the fall, and to decide not to make any changes in response to the comment for the reasons staff have listed in your materials, unless you have any additional direction you'd like to provide.
So just to remind everybody that the language was previously approved. So the possible motion, of course, with all of these possible motions, you're free to deviate and create your own motion. But if you wanted to go this route, you would be approving the language as it was already previously approved. In essence, you would just not be making any changes in light of the comment that was received during the 45-day comment period. And then, excuse me, in the materials, there was a draft response. As Heather said, we have a duty to provide a response to the comments that we receive. And there's a draft of some language there in the materials of what the response could be. So if you're comfortable with that response and with the language as it was already approved, then this possible motion that's in front of you on the screen would be fitting.
All right. Again, any comments or questions from the board? All right. I would like to make the motion, this motion here, to adopt 16 CCR 1427 as notice, direct staff to take all steps necessary to complete the rulemaking process, including responding to comments as discussed today, and filing the final rulemaking package with the Office of Administrative Law. Authorize the executive officer to make any non-substantive changes to the proposed regulations necessary to complete rulemaking process. Do I have a second?
Woods.
Thank you, Elizabeth. BRN moderator, can we open it up for public comment?
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Please also remember, if you would like to make a comment in a different language, to state that as well. Thank you. Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you. All right, we'll take the motion to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan.
Yes.
Susan Naranjo.
Susan Naranjo, yes.
Elizabeth Woods.
Yes.
Imelda Ceja Bukowitz.
Imelda Ceja Bukowitz, yes.
Jovita Dominguez.
Yes.
Trisha Wynn.
Trisha Wynn, yes.
All right, motion carries. Thank you. Item 5.0, discussion and possible action to accept or revise the responses to the Board of Registered Nursing Sunset Background Paper. So the background paper was posted in the materials for the meeting. We need, Reza, we just need a motion to either accept it or reject it. Okay. All right. Motion to accept. Okay, I would like to make a motion to accept the Board of Registered Nursing sunset background responses and give the authority to the executive officer to make non-substantive changes with the admin committee to have final sign-off authority. Do I have a second?
Trisha Wynn seconds.
Thank you, Tricia. BRN moderator, can we open it up for public comment?
The comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you. All right, we'll take the motion to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan.
Mary Fagan, yes.
Elizabeth Woods.
Yes.
Imelda Ceja Bukowitz.
Imelda Ceja Bukowitz, yes.
Jovita Dominguez.
Yes.
Susan Naranjo.
Oh, yes.
And Trisha Wynn.
Trisha Wynn, yes.
Thank you. Moving on to 6.0. This is the report of the Legislative Committee. I am chair. Is Gurpreet here?
attendees and see if we can elevate her.
Thank you.
No, she is not there.
Okay, I'll have board staff reach out to her, but we'll go ahead and start Dolores and see what we can do to move forward. Give me 1 second to pull up my notes.
As information to the board, we will be taking a board vote position on bills that we have no previous position or bills that have been modified.
With the exception of one. And so Dolores, you had asked us to speak about a direct impact bill, AB 646, that is authored by Lowe. It is a Department of Consumer Affairs wide bill for expunged convictions. It was introduced in 2021 and is moving now. The board took a watch position back on February 16th, 2022, but after discussions with various stakeholders, there have been some concerns brought forward, and our board president wanted us to kind of have a conversation about that and see if we wanted to change the motion. So what this bill does right now, it requires a professional licensing board to update or remove information posted on its online license search system, so our Breeze, about a revoked license within 90 days after receiving an expungement order related to the conviction as specified. It also requires the board to charge a fee of $25 to cover the reasonable regulatory costs. The intent of this bill, the author wants that if a licensee is charged or convicted has been expunged, that the record should be removed on the licensing board system search, so that it doesn't serve as an unjustified reputational detriment. What happens with BRN, that the issue that brought up is for nurses, these charges and convictions would still be visible on the NCSBN license search system. So if you go into NCSBN, they are a national practitioner database. And what they do there is you can type in any RN license for any state in the nation, and it would show that there was a disciplinary or a denied license or some sort, and then it would show what occurred, and then it would state that there was an expungement. Similarly, the Med Board has in their statute an ability for that information to be updated within 6 months versus 90 days. And it has the ability that they just mention that there was an expungement and they place the expungement. So that would seem to be a much more favorable option. And we would like to kind of have conversations around that, maybe a support with amendments or oppose unless amended. Because what would happen is we, at some point in the review for license, get wrap back. That wrap back is considered through our enforcement department, and we may, based on our disciplinary guidelines or based on review and board vote, say that we're not going to license that person. And then we've denied licensure, but then years later, they go in and get it expunged. Now we have no true reason to validate why we denied that licensure, because that expungement now occurs and everything is deleted. So the conversation was, if we followed some of those processes that the Med Board had, that it would allow for a tracking, a trail that says the board denied licensure based on this, but now we've given licensure because it is expunged, and it would still be out there. Some of these expungements, in order for them to happen, of course, were felonies. They did get dropped down to a misdemeanor, and then that misdemeanor is what is expunged. So Rez is on this call. We've had some conversation with him. He could speak up if he wants to add any more information, but that was really the intent of bringing AB 646 forward again after we had a watch position, just to make sure that board was aware of the impact and maybe suggest some language or a different position, but that's why Dolores asked us to bring that one forward. So that is AB 646, and it's a low bill.
May I ask a question?
Sure.
Are the offenses that, fall under the jurisdiction of this bill, is it every offense? I mean, is it sex offenses and drug offenses and, DUIs, or is it specified? I wish I had looked at this ahead of time. I'm sorry I didn't.
No, that's okay. My understanding is that it doesn't specify that it is any expungement. So it could include those more egregious areas that then are dropped from a felony to a misdemeanor and then expunged. And that was kind of the concern that we had when we were looking at this more thoroughly.
Thanks, Lori. Yeah, I have a concern about that too. Thank you.
It specifically identifies expungements. The bill and the new statute that would be implemented pursuant to it doesn't really talk about the specific crimes that it could or could not be expunged. It references the type of expungement issued under Penal Code 1203.4, which is a pretty common type of expungement that we see. I'm looking at 1203.4. It's kind of a lengthy section. I'm not sure off the top of my head if that section has any limits on the types of crimes that can be expunged pursuant to it. But this bill, it deals with expungements under 1203.4 of the Penal Code. You can keep discussing. I'm going to skim this section here, and if I
have a question, Reza.
Yeah, of course.
It's an expungement. Can it be either for a misdemeanor or a felony?
What Lori, I think that's what was talked about here.
I'm sorry, I didn't hear the question and I thought it was directed towards Reza. I apologize. Can you repeat
go
the
ahead.
question, Betty?
The question was, can both misdemeanors and felonies be expunged, or is just for a misdemeanor?
So typically, in order for a felony to be expunged, they do a plea bargaining or some sort where they drop the felony to a misdemeanor, and then that misdemeanor is expunged.
So section 1203.4, and again, I'm sorry, I'm aware of this section, but it's not one that I'm not a criminal attorney, so I don't know the details of it off the top of my head. But as I'm looking at it, excuse me, section 1203.4 generally lays out the possibility of an expungement. It does say that this section does not apply to any misdemeanor it does not apply to certain specific types of crimes. One is any misdemeanor within section 42002.1 of the Vehicle Code. Let's see what that is. Okay, it's some kind of a driving offense. 1203.4 does not apply to certain sections within the Penal Code, 286, 287, 288, and those 286, 287, 288 are, again, I'm just skimming and giving you what I see at a quick glance, but they're generally related to sex crimes. First word that I see here is sodomy. So there are specific carve-outs from 1203.4 that you can't get an expungement pursuant to 1203.4. And if you want, I could spend a little bit more time giving you an idea of what all of those carve-outs are. It would just take a moment for me to look up each of these code sections and tell you what those generally pertain to. happy to do that if you'd like, but just let me know.
Interested in that. Tricia, again, speaking, I'm encouraged that it doesn't include sex offenses because it seems like that's absolutely kind of someplace where we shouldn't go. Again, if it's drunk driving or something like that, I'm much more comfortable with it, especially if it's been knocked down to a misdemeanor. So those are just my thoughts.
Yeah, while Rez is doing that research, I can talk about the Business Professions Code 2027 that is part of the Medical Practice Act. This was brought up in conversations with our Ledge Committee Chair and our Board President and DCA, their legislative team. And in BPC 2727, it gives specific call out for felony and for misdemeanors. It gives 6 months rather than 3 months. And another provision allows for the medical board to post the notification of expungement order and the date thereof instead of removing the initial conviction altogether. So the intent of this bill is for essentially ease of employment and not kind of keeping people down essentially while they're doing what they can to kind of turn their life around. They're getting things expunged. They need to get in and be able to practice. And so this bill is something that we did vote as the board to watch. We could continue to watch. We could go to a support position or opposed position. With the discussions with our board president, who was serving in the role of the Ledge chair, and DCA's Ledge council, was that our med board has a specific call out for specific things just like this. And so although this would affect the majority of the DCA boards and bureaus, it doesn't affect the med boards similarly because they have BPC 2027. I could pull up BPC 2027 and share it on my screen if that's something that's helpful. And so that was really where this conversation came from. So just so you guys know, as we're kind of working through this to see if that is a position that our board wants to take.
To pull it up, Lori, so that they can see the med board statement.
Great, thank you. And then just so you know, Board President Trujillo, we were not able to get a hold of Gurpreet at this point. So Matthew Yates, our board operations supervisor, will be elevated from an attendee to a panelist, and he will do the rest of the legislative updates with me assisting, but he will kind of carry that. So I will screen share real quick, unless Matt wants to do that. Matt, are you able to screen share and pull up 2027? And are you ready to go?
I can't screen share, but I can unmute and mute myself. So I think I'll stick to just speaking. And if you want to go ahead and pull things up, that would be great.
I will screen share right now. Give me 1 second to get that up and going.
And I will do my best to do as good of a job as Gurpreet.
Thank you for stepping up. So on my screen right now, are you guys able to see the California Business Profession Code 2027?
Yes.
Okay. So on there, it talks about what it posts to the internet website. This bill specifically talks about our license lookup. It would not be our website, it would be the Breeze license lookup. And I'll scroll down to the section that particularly brought us some peace when we were looking at this. Is it right here in number 4 and number 5? I'll highlight it for you guys, where it says, upon receipt of a certified copy of expungement order, and you guys can read that there, and I will let Matt take over from there, and I'm going to try to mute. Mark, can you mute my mic? It's not allowing me to mute.
So if you have any further questions on 646, otherwise we can just keep going with this. I think we have a few bills we need to cover.
Yeah, we don't have a motion on this one yet, or a first and a second. And so typically, Matt, we talk about a bill, we get a motion with a first and a second, and then we'll go to the second bill. and then we open it up to public.
And then we vote at the end?
At the complete end, yes.
Thank you. Okay.
So we do need a motion. We need a first and a second before we can move to the next bill. And thank you again for jumping in. I know this is not your forte.
We could do a support if amended.
And then do you want to
Okay.
specify the amendments? And that would be to allow us 6 months from the receipt and to add that with the notification.
Yes, that it mirrors this language that the Med Board has.
One other thing, I just want to make a clarification. Excuse me. One of the things that I noticed in looking at the Med Board's authority under 2027 and looking at AB 646, 646 creates a new business and professions code section in the general B&P. So 493.5 is the new section. That would apply to basically all of the boards, and the Med Board included, except that in 493.5 there would be a carve out that says this doesn't apply to Med Board insofar as it is in direct conflict with section 2027. So where 2027 conflicts with 493.5, the Med Board's statute prevails, but otherwise they are also subject to 493.5 if to the extent there is something not in conflict or something that their own statute is silent on that AB 646 does address. They're also tied into it. So if you were looking to get authority along essentially parallel lines of what Med Board has, you'd be asking for a new statute in the Nursing Practice Act and an addition to AB 646 that likewise carves us out the same way they did the Med Board. So you'd have to be pretty specific, and you could identify specifically what you want, or you could identify a little bit more generally what your concerns are with the bill, and take a approve if amended, or I'm sorry, support if amended, or oppose unless amended position to let the legislature's office kind of deal with making the fixes for us if they are so inclined.
This is Betty. Personally, I think there's a lot of information that at least I don't understand about it. I don't want to be voting to accept something. I'm more apt to take a look at it at some other point in time, and maybe we can get a better understanding. Maybe it's me, but I don't quite understand the whole issue around here. I think we really need to know what somebody applying for a nurse or a nurse, really what has happened. The fact that they something expunged and this, that, and it's called something else. I like to know what happened at the beginning. What was the accusation? So that's my 2 cents about it.
The concern is if we went with the way that the bill is right now and we supported it and it is passed and we didn't do a carve out for the BRN, we would never know, the public would never know why that decision was made at the beginning, because once that expungement is received, everything is deleted.
This is Tricia again, and I hate to be a broken record, but I am very concerned also if there is behavior and a conviction that we took seriously at one point and then it just gets wiped out. I worry about that. So I would love to see the carve out, and I would be willing to support the bill if that carve out was granted.
Susan Naranjo, and I just I would like to see the carve out, but at the same time, I'm thinking about the intent of the bill and considering where we are in not just in California, but our nation, who is receiving these convictions. And no one just receives an expungement, it's a process. And so, why are we making someone go through another trial essentially? It's information to know because it is our job to protect the public. And that's why I'm agreeing with the statements here. But I also want to raise the intent and who this is designed to help. Keep that in mind, please.
Thank you, Susan. And once we get a vote on this, if the intent is to support the bill because of the intent of the bill, and there is some recommended amendments, my ledge staff, myself, can go ahead and then have those conversations with the author to see if we can get those amendments and continue to support the bill because the intent is appropriate.
I'd like to make a motion to support if amended. Do I have a second?
This is Mary, I'll second.
Thank you, Mary. Let's open it up for public comment, please.
We will be opening.
Sorry, this is Reza.
Yeah.
I guess maybe now would be a good time before the public comment and before it comes back. So you asked me to kind of look at what's not eligible for an expungement under section 1203.4. That's one thing I wanted to address. And then also one other thing that I'll touch on. So I could screen share. I've taken some notes on what the specific crimes that are not included in section 1203.4, basically the crimes that you cannot get that type of expungement for. But I think if you'd like to see it visually, I can do that. Otherwise, I can explain it pretty simply. Pretty much all of these relate to the one with the vehicle code is kind of an oddball. It relates to disregarding any traffic signal or direction given by a school crossing guard. All of the rest of them relate to sexual acts done with a person under 14 years of age, or looks like the rest relate to like child pornography type crimes. So those types of things you can't get a 1203.4 expungement. It appears beyond that that 1203.4 does allow an expungement. And again, take that with a grain of salt. I'm kind of doing this on the fly. But the other thing I just wanted to mention, it's some of you who are around will recall we did some work with Assembly Bill 2138 back in 2018, that kind of general time frame. And those of you who are newer may not have been aware of that. This bill kind of ties in with that general theme of allowing individuals who have a criminal past to kind of rehabilitate themselves and get a fresh start and be able to secure a license to engage in a profession as a step towards re-entry into society. That was the policy behind AB 2138 and presumably behind this AB 646. That's not to say, there was a lot of controversy about it with AB 2138, especially amongst our licensing boards. And I would imagine, this being of the same kind of, in the same spirit, also controversial because it's, there's a lot of questions around it. But that's kind of the general spirit of it. I'm not advocating or anything for one way or the other, but just wanted to kind of tie it in, like Susan was saying, that there's this other public interest that this is trying to serve. It would impact our ability to, give information to the public. On the other hand, it serves the other interest of allowing folks with criminal histories who have gone through the process, as Susan said, and obtain an expungement to put that behind them in a sense. So that's all. If you did want to see this code section 1203.4 with my notes about the carve-outs, let me know. But I think it's pretty consistent about either child pornography or various types of sexual acts with children, basically.
May I make a quick comment?
Absolutely.
Sure, Tricia.
Thank you very much. Reza, thank you very much. That actually really alleviates a lot of my concern. And Susan, I really wanted to thank you also for reminding me the intent of this bill. And so with Reza's comments, I do feel a lot more comfortable with a support amendment with, maybe a carve out for the BRN. Thank you very much.
Thank you, Tricia. All right, we have a motion and a second on the floor. Is there any other comments or questions from the board?
I have a question. I'm sorry. Can we reiterate the motion? It was.
So I put a motion out to support if amended, and Mary Fagan seconded it.
So I find it helpful to identify the amendments that you're seeking. Can we kind of wrap that up into the motion as well? Or I mean,
Sure.
if you want to take that up afterwards, but we need to know, because a letter, generally a letter would be drawn up and sent to the legislator's office to let them know what concerns we have about the bill, so that the more clear idea you can give about the amendments that we seek, or alternatively just the general concerns that we have, that would certainly help in drafting it and more closely aligning to what you.
I was thinking about closely aligning with some of the med board carve out.
I thought, based on Lori's comments, that we were going to let the Ledge Committee actually put more specifics into. Did I misunderstand that?
We did say, Lori did say that.
Okay.
You're right.
And
Yeah, so the Ledge Committee, we can definitely put more specifics into it, but we do have to have a board motion. So my thought would be support with amendments, and that the amendments specific are to allow for the similar carve out to the Med Board. That is 6 months to update the website, and to add to post the notification of an expungement order, the date thereof, instead of removing the initial conviction altogether. Is that what you guys had decided on, those two things? Because with those two things, we can then draft our support with amendments letter. We can ask for the 6 months instead of the 3 months, and we can ask to post the notification of expungement, the date, instead of removing the conviction.
Is that agreeable to the board members? Are there any other ideas or questions regarding that?
That's fine with me. I'm just wondering, do we need to have that in the motion, or is it just work?
It does need to be in the motion for me to ask for those specifics. If not, it would be me going out on a whim without board direction saying this is what I think they wanted. But if it's included in the motion, then I can ask for those specific recommendations. And then I could take the conversation that occurred here and put that into the letter to say why.
Dolores, do you want to restate the motion?
Well, I would like to make a motion to support, if amended, with the 3 items that Lori mentioned. She mentioned it far easier than I would. You
Dolores,
said 6 months?
Dolores, I can make the motion, and if it's what you want, you can say that's the motion.
Okay.
And that is support with amendments to allow for a similar carve out as the Med Board, to have 6 months for posting rather than 3. And the posting would notify the public of the expungement order and the date that it was received, instead of removing the conviction altogether.
That's it.
So that would be the first. We need a second. Okay, it looks like Gurpreet has joined us, and she is ready to go on past AB 646. Matthew Lates will stay on in case he is of any assistance, if she's got technical difficulties or anything, so that we can continue the movement of the board ledge.
Thank you. So we have a first and a second on the floor. Can we please open it up for public comment?
We're actually doing that at the end, Dolores, after we go through all the bills.
Okay. Great.
So we
Okay.
can move on
great.
to the next bill. I believe it's AB 1662 Gibson.
Yes.
Morning, board members. My apologies. I was having network issues and they're resolved now, and so I'm able to join. I couldn't be reached on the phone either. My apologies. It's been taken care of. So I am Gurpreet Kaur, legislative analyst for the BRN, and I will move on to 1662. And I did want to provide you a brief, quickly, where we are in the legislative session at the moment. We're about 5 weeks short of halfway through year 2 of the 2021-22 legislative session, which ends on August 31st. Bills are being scheduled for hearings in policy committees at this time. The legislature will adjourn for spring recess from April 7th through April 18th. April 29th is the last day for policy committees to hear and report fiscal bills to appropriations. May 6th is the last day for policy committees to hear and report non-fiscal bills to the floor. And as you may have noticed, we from the agenda and the bill summaries and with the discussion that was ongoing before I joined, we have quite a few bills that have been added since the last board meeting. I will be presenting these new bills. And you've discussed one, which was from the last meeting, AB 646, and the other one, which also had a watch position from the last board meeting, is SB 889. A few are still spot bills or placeholder bills, as I will point out. And I will be following the order as listed on the agenda. So moving on to 1662. This is Assemblymember Gibson's bill, licensing boards disqualification from licensure criminal conviction. This is a DCA-wide bill, and it authorizes a prospective applicant that has been convicted of a crime to submit to a board a request for a pre-application determination that includes information provided by the prospective applicant regarding their criminal conviction. The bill would require a board that receives that request to determine if the prospective applicant would be disqualified from licensure by the board based on the information submitted with the request, and deliver that determination to the prospective applicant within a reasonable amount of time. And the intent behind the bill is to, it seeks to provide an early notice on whether an individual's record will disqualify them from obtaining an occupational license prior to financial and educational investment in the requirements for the license, putting California at the forefront and in line with 20 other states that have already advanced a similar policy. So there is a BRN concern with this bill. For nursing students, academic clinical facilities require a background check that is typically completed through the service provider Complio. BRN's review of inquiries received pursuant to this bill would address possible issues pertaining to licensure and not whether schools would be able to place students at clinical facilities. So it is possible that something that makes them ineligible for licensure would make them, ineligible for clinical placement, and they may decide not to pursue nursing school. Still, BRN's response to these inquiries would be based on the information provided by a prospective applicant, which may be incomplete, although it would behoove them to provide a full disclosure. So the fiscal impact is substantial for this bill. BRN has estimated that it can receive more than 8,000 requests from prospective applicants. This will result in a significant workload and additional staff resources estimated at 12 analysts, 7 office technicians, 3 managers, and additional costs for postage and storage of information and files. This bill is scheduled for a hearing on April 5th in the Assembly Committee on Business and Professions. So it is moving forward, you know, and it has support from the Little Hoover Commission and a few others that we know of at this time. Any questions on this bill?
Any questions from the board or comments?
My concern is I think we have, you know, so much work that we're doing on really facilitating and improving our process for licensure anyway, to add additional work at this time. Not that it's maybe not the right thing to do. I'm just very concerned about how we would be able to accommodate this and still, you know, continue our improvement efforts to increase our licensure turnaround time.
And so
Yeah,
Mary, I could jump in on this real quick. This actually wouldn't go through our licensing department at all. This would be housed within our enforcement department, but because of the projected number of inquiries, we would actually have to develop an additional unit within our enforcement area to look at all of just these. The other thing that comes to mind when we're looking at this on whether or not this is something we can implement is, does it serve the intent that the author is going for? The way that we do our enforcement reviews, we wait for DOJ and FBI wrap back. And that tells us everything. What this would do is strictly word of mouth from the applicant. So it may be incomplete. It may not have all of the items that we would need in order for them to do a thorough review. Additionally, this review is done years before licensure. This review would potentially be done before they're applying to get into a nursing program, to see that, you know, before I invest my time and my financial aid and resources, could I get licensed at the end of that? Many things can occur in the years that they're in school, additional convictions, additional items that would then show pattern or something that we would look at differently. The other thing, and I'm sure that you understand, is with your hospital, you actually, for clinicals, require a live scan that specifically goes to the hospital that you work at for people that want to do clinicals there, Mary. So that we could say at our board, yes, on the information that you give us, it looks like you can obtain licensure, but they get into school, they do a background check that goes to the clinical facility, and the clinical facility could still reject and not allow them to get the clinical hours that they need, complete and progress. And so they could still be incurring a student loan debt, getting that time, getting in, but then still not be able to complete their education because the clinical facility would not allow for them to complete the hours. So again, within nursing, this has a little different layer that comes in there that is different than other boards and bureaus that would be affected by this. So hopefully that clears that up a little bit, Mary.
Any other questions or comments from the board? I would like to make a motion to oppose.
I second that.
Thank you. BRN moderator, can we open it up for public? Oh, never mind.
No, go to the next bill, Dolores.
Habit.
We'll get this. That's habit. I totally get it.
You finally got me into the habit of asking for public comment.
Seconded.
One down. There we go.
All right.
It was-
Sure.
Who
Moving
did
on.
It was
the
Mary.
second? I'm
It
sorry.
was Mary Fagan, I second.
All right. So moving on to AB 1756, Assemblymember Smith, Department of Consumer Affairs. This is still a placeholder bill with substantive language to be added. No current impact on this bill. So we can actually move on to the next one. AB 1996, Cooley, State Government Administrative Regulations Review. This bill will require each state agency to, on or before January 1st, 2026, review that agency's regulations, identify any regulations that are duplicative, overlapping, inconsistent, or out of date, to revise those identified regulations as provided and report to the legislature and governor as specified. The bill would repeal these provisions on January 1st, 2027. This bill is substantively similar to AB2, Assemblymember Fong's bill, which died earlier this year. The fiscal impact for AB2 was estimated at 123,000 to about 135,000, with the hiring of one limited term regulatory analyst for 2 years in the classification of an AGPA. The intent of the bill is regulations are designed to protect the public and ensure fair competition in the everyday lives of Californians. Each regulation, though perhaps defensible on its own merit, adds yet another layer to the regulatory thicket. This thicket is especially overwhelming to small businesses with little to spend on the lawyers and accountants necessary to ensure compliance. When left unchecked, the regulatory thicket threatens positive economic change, which can discourage aspiring entrepreneurs who stake their livelihood on the success of their business. So this bill has been referred to the Assembly Committee on Appropriations. It has wide support from businesses, small businesses, from the California Chamber of Commerce. So that is substance of this bill. Any questions?
Is this being done already? I mean, when we do regulations, don't we crosswalk them?
Regulations. This bill, we've had versions of such legislation coming up, every so often. But so it's really asking for cleanup of regulations, things which are duplicative, those kinds of things. So,
But is that being done already? Things that are duplicative, is that being cleaned up now?
I'm not sure about that. I'm sure there's a process, it's looked at things and that takes place as well, when that comes to our attention. So, but I'm not sure if there's a process like that being done currently.
This is Reza. I can speak to what I know about that. I've been with this board for a short amount of time, well, a couple of years now, I guess. Depends on whether that's short or not. But anyways, I would say when we're working on a regulation package, of course, we look at all of our regs to make sure that the general subject of that particular regulation package, based on the subject of that package, we sweep in all regulations that we currently have that would either need to be amended or repealed or changed because they specifically tie into the subject matter of that rulemaking package. Aside from that, I would say ideally we would be going through and doing cleanup of obsolete or redundant or other regulations that don't need to be there. That's admittedly probably more of in a perfect world situation. We have a number of rulemaking packages at any given time, and they're all kind of given some sort of priority depending on a lot of factors. This bill seems like it would probably just be an extra nudge for us to go through and clean up our regulations and probably couldn't hurt. I can probably think of some, at least, a small number that could use either an update or just being taken out of our regs. So in short, Dolores, the answer to your question is I don't believe we have any current active rulemaking packages that are kind of this nature of just general cleanup. But
and this is DCA wide.
I could speak onto it a little bit more, Dolores and Reza. So when we hired the regulatory analyst right after I came in, I believe it was August after I started, We have one reg analyst, one ledge analyst, and we're currently in the hiring process for the chief of ledge. So with that one reg analyst, we started to pick up and clean up all the regs that we still needed to implement that had been left unattended for quite a while. And so we're still in the process of catching up on that. We do have 4 regulatory packages just this year with the Office of Administrative Law. That's something that BRN has not done in years or ever, to have 4 packages in 1 year. We do have AB 890 that's continuing to move forward with that reg package that's taken a high priority. We have another reg package coming through with the implicit bias update that just came into effect January of this year, that is now being added to the other CEU update with the implicit bias. And so we have a spreadsheet that we keep up to date, that we work with the DCA's reg team, Heather Hoganson, on here to prioritize reg packages and move them through in as efficient ability as we possibly can. With doing that, we do know that there are some regulations that we do have to update. Two, that the one that I believe that the board voted on in November to update was 16 CCR 1426, that talks about our curriculum for our pre-licensure nursing programs, because yes, it is outdated and not serving the way that it was intended to serve. So we will be updating that as well. There are a few other regulations out there that have been identified that will be updated as we get to them. But specific for this bill, we would hire in a limited term regulatory analyst if this were to pass, and have that person only focus on cleanup instead of having cleanup part of our normal regulatory process. And so as Reza described, that's absolutely correct. When we go to look at a item that was brought to our attention from either a stakeholder perspective or an employee that says, hey, this doesn't serve us anymore, then we look at all of the other regulations that surround that to see, are there any updates that need to be done? One of the, an example of what occurred when COVID hit is the schools, the nurse practitioner schools, were immediately adjusting their curriculum, bringing it down to the minimum requirement of a direct patient care. In our updated regs in 1484, it said 500 hours was the minimum requirement. There was an error in that regulation that had a calculation further down that had the minimum requirement calculate as 554 hours. So when that hit and it was identified, that was noticed. And Heather worked with that and had it updated with a Form 100 that allowed for it to stay at minimum 500 or at or above 500. And so that was actually just done and completed because that was identified by stakeholders that we needed to update that. And so we do have a process in place. It is an ongoing process. It's not a one-time kind of look like this bill is asking for. And so if this were to pass, we would hire in a person to do the one-time look to address all regulatory packages. And then the great thing with that is it would repeal them all in a one swoop. So there is some issues with this, but we could implement.
I'd like to make a comment. Sounds to me like we're ahead of the game, which is really good sense. That's great that we're ahead of the game. I think by accepting this bill, AB 1996, we'd be transparent. I mean, we're doing all that we can. So when it came to review, it's just to check some balances. And I think we should go. If we don't, it's going to look like we're hiding something, and we're really not. We're ahead of the game. So I see no problem with accepting this bill.
Yeah, the only thing that it would have as an impact to the board is that it would have a fiscal impact, and that was the money to pay for the person for that amount of time, and then paying for the regulatory process to move through. But that would be it. Our budget at this point could handle it, and we could move forward, Imelda.
This is, make a comment. Thanks. This seems like a good idea. This is a good government bill, and I'm really glad to hear that our board is, or, you know, this entity is way ahead of the game. I'll bet there are lots and lots of other boards that are not doing this. They're not updating their regs. So I think it's a good idea. I think it's something we should support. And I'm glad we can afford a one-time staff person to come in and just kind of help us clean up.
Yeah, this is
Thank
Mary.
you. And then, oh, sorry, go for it, Mary.
Yeah, I do also think it's a very good idea. I do have a question of what, do we know what type of reporting requirements the bill would impose upon us?
There would be some, and I was actually just going to open up to Gurpreet. Gurpreet, are you able to share the opposition that has been shared about this bill? Do you have that in your review?
So there is no, I don't have that for this bill, but the bill that was identical to this from last year did have a few opponents. One stands out, a CNA stands out. I think there were a few others as well. I don't have all the whole list or all of
No
them.
worries. I was able to quickly pull it up. Right now for opposition, it looks like California Labor Federation, Northern California District Council on the International Longshore and Warehouse Union, California Nursing Association, California Alliance for Retired Americans, California Pan Ethnic Health Network, Health Access California, and Western Center on Law and Poverty Incorporated. So those are the oppositions that are listed currently on this bill.
What were some of the oppositions? For what reasons?
Coalition of labor unions and civil rights organizations have concerns that it would divert staff resources from their normal duties, which include updating and promulgating regulations, and create detrimental impacts to worker safety and healthcare services.
And then just for additional clarification, if you go to our website under rn.ca.gov and you're in the meetings section, there is oppose and support letters that were turned in. As you know, if we were in person, if a public comment person would show up and have oppose or support letters, they would hand them out to the 9-member board, and then we would put that into our meeting materials. As we're not able to do this in person, we were sent some opposition bills and support bills, opposition and support letters, related to the bills that would be presented today. They are on our website. And so this bill right now is AB 1996 Cooley. It does look like CNA has opposed it. They do have a letter that is in our materials. It talks about existing law already addressing these issues, regulations are protections. It talks about diverting scarce public resources away from protecting California's, and it does not safeguard important health and safety protections. And so I'm sure when we open up to public comment, there will be more talks about this. But as you guys are going through this, I would like to point you to any of the support or oppose letters that we have received. Currently, it was just from California Nursing Association. We haven't received any reach outs to have any additional letters posted. But as Reza has explained, we can post any items that are received about 24 hours around the meeting. So if we do receive any other support or oppose letters for these specific bills that are talked about today, we can add those to our website. I would just ask that they're emailed to myself, and that would be loretta.melby@dca.ca.gov. And my contact information is also on the website.
Hey, Laurie, this is. What bill already exists that covers this? What bill?
There was bills put forward that Gurpreet talked about that was, this is a similar bill to AB2 that Fong introduced last year. It died. It didn't make it through. So we don't have similar law. We had a previous bill that was introduced. As just part of our clarification practices, we do cleanup of regulation. This would be a one-time snapshot. So hopefully that helps to clarify a bit.
Yeah, I think I'll add to that. I think, Imelda, you were asking about the opposition that's been put out there. I'm reading from the legislative analysis. It reads, some of the opposition states that the existing rulemaking process through the Administrative Procedures Act is designed to ensure proposed regulations are necessary, not duplicative, clear and consistent, go through open public review, and are allowed by law. More importantly, the APA provides for a strong public comment process, and it goes on. There is existing statute in the Administrative Procedures Act that requires all of that, what I just read, that any regulations that we intend to pass be necessary, not duplicative, clear and consistent. The one thing in my view that's not really addressed in current law is an affirmative obligation to do a run through of our regs and amend or remove any that are outdated or that have since become inconsistent. At the time that we pass it, a regulation, it has to meet the necessary standards that the Office of Administrative Law looks for. They're set forth in law: necessity, clarity, consistency, etc. But once it's in law, I'm not aware of a statute that says we have to go back and, I mean, obviously that's something that we should do, but this would just put something in law that says by a certain date, 2026, we have to go through and clean up. And so I do think that there is potentially some elements that are not in the APA that are sought to be added by way of this bill. Somebody asked about the reporting requirement. There is a requirement to report to the governor and the legislature on the state agency's compliance with this chapter, including the number and content of regulations the state agency identifies as duplicative, overlapping, inconsistent, or out of date. So there is a report required at some point in the process.
And this is Mary again. Does it also, because the one thing it said, it would repeal the provisions as of January 1st. Does that expedite the process with this having this January 1st date of everything being repealed? Or is that how the process would normally work without this legislation?
It would work similar to that without this legislation. What this does here is that it has a due date for everything. So the review would be completed by 2026, and then it would give the legislative season an ability to remove and repeal everything by 2027. What we would do right now is, if we identified a reg that needed to be removed, is we would put that through, and that would then be removed as soon as that was reviewed by OAL and repealed. And so it'd just be a continual kind of working process versus a one and done.
I think it sounds like a good idea.
So would the motion be to support?
Yeah, I'd make a motion that we support this.
Is there a second? Thank you. Capri, can we move on to AB 2104, please?
And so AB 2104, Flora's bill, Assemblymember Flora's bill, this is professions and vacations. This is actually not going to be advanced by the author, and it has no further impact on the BRN. So this one really will be removed from our tracking list. Going on to the next one listed on the agenda, AB 2107, again, Assemblymember Flora, Department of Consumer Affairs. This was earlier a placeholder bill. It has substantive language which has been added since was added on March 17th. It is now an indirect impact bill, and I will present this bill with those bills further down after we're done with the direct impact ones. So moving on to AB 2188, Assemblymember Quirk, discrimination in employment, use of cannabis. This bill amends the California Fair Employment and Housing Act to make it unlawful for an employer to discriminate against a person in hiring, termination, or any term or condition of employment, or otherwise penalize a person if the discrimination is based upon the person's use of cannabis off the job and away from the workplace, or with prescribed exceptions upon an employer required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their urine, hair, or bodily fluids. So the intent of the bill is that it says that the intent of drug tests is to identify employees who may be impaired, while there is consensus that no one should ever show up to worksite high or impaired. When most tests are conducted for cannabis, the results only show the presence of the non-psychoactive cannabis metabolite. Testing positive for this non-psychoactive cannabis metabolite does not indicate that the employee is impaired and has no correlation to workplace safety or productivity. The bill would also clarify that employers can continue to test for impairment by testing for THC, which may indicate impairment in an employee. So this bill is currently in the Assembly Committee on Labor and Employment.
Any questions or comments from the board?
Is there opposition to this bill?
I can quickly take a look. I hadn't seen anything. Sometimes it put up the analysis the committee does. There is no committee analysis for this just yet, so I don't have that. We don't have that information as far as opponents. There is support. I got that information from the author's office. But I'm not sure who's opposing this at this time.
I would like to make a motion to support the bill.
This is Mary, I'll second.
Thank you.
All right. So moving on to the next one. AB 2397. This one is Assemblywoman Dolly's bill, and this is for the title is Board of Registered Nursing Online License Verification. This has already been, nurses, it relates to nurses, requires the board to consult with DCA no later than July 1st, 2023, and develop recommendations for the implementation of the nurses online license verification system for verifying the licenses of California nurses seeking to practice outside the state. So nurses for license verification was implemented by the BRN on March 10th. This year, just this month, which makes these provisions redundant. So it's really it's something which has been implemented already.
So we don't need to take a position on it, correct?
You don't have to.
We would take a support position.
Sure. I would like to make, wait, any other comments or questions from the board before I make a motion? Okay, I would like to make a motion to support. Do I have a second?
This is Mary, I'll second.
Thank you, Mary.
Real quick, just a general point, not necessarily tying into this bill, but on the question you just asked, Dolores, you don't necessarily need to take a position on any of these. You could take no position, you could take a watch position, or of course you could support or oppose. So you always have that option of just.
Since we were already implementing it, basically, Reza, I didn't know if we still would do that.
Yeah, this one, it's a weird situation, but that was just a general point again.
It probably won't advance, right?
Not sure, actually. I reached out to DCA because this was confusing for me as well. I'm like, we've already done this. I'm not sure why there's a bill saying we need to do this if we've already done this. And they said that would be easy. You just take a position of support that shows, and then we would write the letter saying to the author that we support this and we've already implemented it and this was our start date. And then my understanding at that point is if they choose to continue to advance it, it would advance, but it could just essentially, that bill would then just die at that point and not progress because they would know that there's no reason to put it forward because we've already done it. But when talking with DCA, they said that we would take a position of support because we've already implemented it. And so that's why when Dolores was equally as confused as I was when it came through, that was the direction that I received, because I was not sure how to handle a bill that said for us to do something that we had already done. So that was the recommendation that I received from DCA.
So I'm not opposed to the motion, but I do wonder why we would put something into law that's completely unnecessary and just have one more law on the books that is irrelevant. So that's just my comment.
This
I
is
got that
the
same
one
comment, Tricia.
somewhat of a tangent to that. It's kind of a quirky issue that if this were to pass in its current form, it does say not only for us to implement nurses, but we should consult with the department and develop recommendations for the implementation of nurses. So if this were to pass, we'd still have to go through that. Probably it would be more of a formality than anything, given that we've already implemented nurses, but there would have to be something to allow us to check off that box saying that we have consulted with the department and developed recommendations.
Yeah, and to answer that, Reza, we actually did, because in order to implement this, it does have to be approved through DCA. It did have to go through a contracting period. You assisted on that contracting as well. That actually went to DCA for contracting approval, and DGS as well. So that recommendations, that collaboration between the board and DCA did occur. So if it did go through and if we did have to address that, we would be able to provide documentation that did occur and that we did move that. So we would be able to we would be able to support the items in the bill to show that we did comply with everything in it. But again, this bill was introduced in February. And what was confusing to me is our board had voted to implement nurses in November. So we're not sure why that didn't carry through to Dolly, who had introduced this bill without the knowledge that it was already in process, that we were in the contracting process with the intent to roll it out. We did have notifications on our website. Our board meetings are public, and that was out there. So we're just not sure where the miss was when this happened. And so we were actually shocked to see this introduced after we had already, as a board, voted to do it and we're in the contracting phase and release.
According to Ledge Info, she introduced it February 17th.
Yeah, and the board took the position in the middle of November of 2021, and we were well into contracting by that point and had the information on our website that we were going to be going live, etc. Prior to that. So that to me was just an interesting happenstance.
Thank you. Capri?
All right, I can move on to the next one. That is AB 2452, Assemblymember Chen's bill. This one was earlier a placeholder bill. It was amended on March 17th with a new title and now substantive language added to this bill. It is no longer applicable to DC or its boards, so we don't have to go over this. It's now Structural Fumigation Enforcement Program. That is the title, so and no longer applicable to the BRN. So moving on to 2600, AB 2600, Assemblywoman Dolly, state agencies, letters and notices requirements. This will require that every state agency, when sending any communication to any recipient, shall state in bolded font at the beginning of the communication whether it requires action on the part of the recipient or serves as notice requiring no action. This bill is currently in the Assembly Committee on Accountability and Administrative Review. And I did reach out to the author regarding this bill for fact sheets, additional information on how they're moving with this bill. I haven't received a response yet, so despite a couple of follow-ups. So I'm not sure if this might be moving forward at all. I have not heard anything, but that is the current, that is where it stands at this moment and what that's doing. Any questions on this bill?
Any questions or comments from the board?
Anything like this now?
I am not sure if maybe Lori can address that.
No, we
No.
do not. This here, I understand the intent of it. Carrying it out is a little bit cumbersome. What this would mean is that any email that is sent by anybody, including you guys as board members from your DCA email box, would require you to start the email off with action required or no action required. And then continue on with the email. And I understand that that is supposed to streamline and make sure that maybe we get action, but I could see that we may be sending out information that would be imperative, but because it says no action required, that people would just delete it and not read it and not go through and get that content and think about it. And so I know that when you're looking at streamlining things, if you're looking for, okay, I need to do all my action items first, that, you know, you at least read the email, read the communication, and then prioritize it based on this. I would think that if you did action, no action, that you may not even get that information to be able to do that critical thinking, to be able to prioritize, that it would just kind of go on the wayside. So I could see some unintended consequences. I understand the intent to be a more streamlined process to make sure that we did get action on the emails that require specific action. But I could also see just the opposite occurring as well. And no, Mary, we have nothing in place that requires anything like this at this point.
Of ambiguity about, you know, there are some things that are obvious that require action, some things that are going to be more of a gray area of whether action is required or it's merely for notice purposes. You know, just one example that comes to mind, we had that declaratory decision process on the question about cannabis administration, and we sent out a notice to our licensees that they have an opportunity to comment. If they want to comment, action is required. If they don't want to comment, then it's, I mean, that kind of comes to mind as something where it's a gray area. If they want to engage themselves in the process, action is required, but really it was just for notice purposes that they have this opportunity to comment and that this proceeding is pending. And that may not even be the best example, but I'm sure there's going to be a lot that kind of fit into a gray area of, you know, uncertainty of whether action truly is required or is it strictly notice only.
I mean, the one area where I think this would be really valuable would be if it's something related to a disciplinary proceeding or something where if they didn't respond, there could be action against their license. So, and I don't know if we do that either, but I agree with this as broad as it is now, it doesn't make sense to do it, but to me, it would make sense potentially if it was more limited scope.
Yeah, so for the enforcement process that you brought up, Mary, we send out official notices that have action required on that says you have 10 days to respond, blah, 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 or whatever specific to whatever's occurring. If it's a cite and fine, we'll say that you have until this point to pay your fee, pay the fine, etc. So we are very clear in that. What this would do is, because it's so overreaching, it's very broad, it says any communication, and you know, that to me becomes kind of could be confusing. And one of the example, the cannabis example that Reza said, you know, he sent out that notice, and some of the nurses that received that notice actually thought that they were being charged with some kind of a cannabis issue, and it was going to be on their license, and they didn't understand why they were getting this notice, because they didn't actually even read the entire notice before getting alarmed because the Board of Registered Nursing is sending something out to their personal email that is talking about cannabis. So it to me, I think would really have a lot more confusion and a lot more alarm that if we said action required and we're sending out a board meeting notification like we do every morning before the board meeting, that action required would be to log in and watch our board meeting, participate. but they would be, oh no, now I need to sign in and watch the board meeting because maybe something is happening that specifically affects me today. I need to do this. And so I just see that there'd be some cumbersome issues with this, a lot of gray areas, like Reza said, where we would put action required if you want to watch the board meeting, no action required if you want to continue on with your day and not watch our board meeting, because it's any communication. And so that to me would just be confusing.
This is Tricia. This bill just seems like complete overkill. I mean, even the notices we get from, enforcement staff, that, it says, hey, this is time sensitive. Okay, like we can figure that out. And it seems like, you guys are doing a great job getting out information. Seems like this needs a surgical approach rather than a sledgehammer. So, I would be inclined to oppose it.
So is that your motion, Tricia? Oppose?
Yes, I'll make a motion that we oppose AB 2452.
And Jovita seconds.
Thank you, Jovita.
Just food for thought. One thing I'll say, just kind of, piggybacking off my own comment, I think, and Lori's, I think there could be a lot of situations where in total good faith and with the intent of sticking to this bill, we send something out that we genuinely believe is notice only, but maybe there's some type of action required if you want to follow up on that notice. Somebody could say we didn't comply with this statute. On the flip side, we may, like Lori said, put action required on something that generally is notice, as for most people who are probably going to disregard it. But then a lot of people are going to be kind of stirred up and confused by it. The one other thing I wanted to just throw out for food for thought, we sent that notice on the declaratory decision proceeding out in late December, and it's now late March. And I still this week have continued to receive emails from folks, just a small number, fortunately at this point, but who, for whatever reason, just now got the message and have contacted me with confusion about what that notice meant to them. So take that for what you will. There's obviously folks out there who could benefit from getting the message spelled out up front, but then again, a lot of confusion that results. Anyways, I just thought it was interesting that 3 months later, folks are getting to that email that went out in December.
And then real quick, it just says a point of clarification. Tricia, you did oppose for AB 2600, Dolly State Agency Letters and Notice Requirements. I think you said a different bill number, so I just want to make sure that it's AB 2600 that you're opposing.
Thank you, Loretta. Thank you for catching that. Yes, that's exactly what I intended.
Great, thank you. And did we get a second?
Jovita.
Thank you. And then Gurpreet, we can move on to AB 2626, Calderon.
Sure. And this one again is a one which is no longer applicable to the BRN. It has been amended. It's now titled Medical Board of California Licensee Discipline Abortion. So no longer applicable and no position required on this one. AB 2636, Berman, that is refugees, asylees, special immigrant visa holders, professional licensing, initial licensure process. This also is still a placeholder bill with no substantive language that is yet awaited and no current impact for this bill at this time. So then moving on to AB 2637, Assemblywoman Rubio, nursing schools and programs exemptions. This bill will exempt an approved School of Nursing or approved nursing program that is accredited and maintains accreditation through a national nursing accrediting agency recognized by the U.S. Department of Education, or is a public institution, is accredited through a regional accrediting agency, maintains a minimum pass rate of 80% on the licensing examination for a minimum of 2 consecutive academic years, and meets some other specified criteria. This bill would require an approved School of Nursing or an approved nursing program that is seeking exempt status to submit an application to the board, and would require the board to approve the application if specific requirements are met. It would require an exempt School of Nursing or a nursing program to continue to notify the board of other changes and to continue to submit annual reports to the board. It would specify that the exempt nursing school or program is not required to pay fees or seek board approval for certain program changes that are approved by the applicable accreditors or within the scope of the program's accreditation. These changes would include, among others, clinical experience placements at a clinical agency or facility that is already approved by the board to provide clinical practice hours. And if the program staff and school or program attest under penalty of perjury that the new clinical placements will not displace existing placements. Additionally, it would also specify that an institute of higher education or a private post-secondary school of nursing subject to the above exemption provision is prohibited from making a payment to any clinical agency or facility in exchange for clinical experience placements for students enrolled in a nursing program offered by or affiliated with institution or private post-secondary school of nursing. So the intent for this bill is to streamline regulatory redundancies that are clogging the nursing education pipeline and expanding access to a career ladder for those already in the healthcare industry. And they're saying it's imperative to combating this looming shortage of nurses, and that the bill will improve the quality of and access to patient care by exempting certain qualifying institutions of nursing training from redundant programmatic regulations imposed by the BRN without implementing efficient and clear regulations that enable timely approval of education programming and nurse licensing. The state risks perpetuating a nursing shortage that can last for decades. This bill ensures that the board does not use its authority under the NPA to control enrollments in nursing programs. So the status for this bill is that it is currently in the Assembly Committee on Business and Professions, and it's not yet scheduled for a hearing, but it's moving forward. Any
Now,
questions?
this is Imelda. It sounds like they just want to strip us from everything that we're already doing. We're doing a great job at it. I'm going to oppose this bill.
And I second it.
I'd like to just, I mean, a lot of what this bill is saying is stuff that came up at the sunset hearing. So I do think, you know, questions about is this duplicative with the accrediting agencies?
Yeah, I hear you on that, Mary, and thank you for giving me an opportunity to address this. And this was some of the stuff that I tried to address at Sunset as well. But we have such short snapshots of time where we can kind of have these conversations. And so when this was brought up in our Sunset last year, we met with deans and directors and we started looking at any duplication, and there was some, and we've essentially removed that. And so based on a lot of the improvements that we did in this last year, this bill, although I understand the intent of it, is not necessarily needed and could create additional workload for our NECs. So I wanted to make sure that we're completely aware of this. When they talk about this, and say that the accredited school needs to meet several areas first. And so that is accredited through a regional accreditation and a national accreditation. So one that it now creates a two-tiered system within our board. Right now we have a continuing approval process that is a singular process within our board that we align with the accrediting agencies now. So if you're CCNE and you're a 10-year visit, we only do the visit at 10 years. If you're ASIN and they do an 8-year visit, we now only do a visit at the 8-year mark. What happens with this now is we would do a 5-year visit again, because not a visit, but a 5-year review again, because what it has is they have to apply and they have to prove that they've met A, B, C, D, and E. that is a report that would be submitted to our NECs for review to ensure that they can get this exempt status. That's an additional workload. That is creating that two-tiered system. Then it says that once you've approved, we've got this, it says that they need to reapply in 5 years. Again, that's another report coming into our NECs to review for reapplication in 5 years. Then when it has the 80% pass rate for a minimum of 2 years, that we already do an annual NCLEX pass rate where we review it on an annual basis, but then we'd also have to go back and check to make sure that the people that had the original exemption maintain that, and we'll have to look at that for a different level. So again, continuing on with the two-tiered system through the BRN, which would increase the workload of the NEC. Then it says the maintain the official cohort default rate as calculated through United States Department of Education annually that is less than 7.5%. Right now, we watch the attrition rate. We don't have anything in regulation that says we can take action based on it. And part of our background paper, we did say we can consider enacting some regulations so that we can have that, which would address D. The difference is that the U.S. Department of Education has a default rate that is calculated on time and a half. And so if the program is set to be 2 years, they don't do the default rate based on 2 years. They do that based on 3 years because it's time and a half of the program. When the BRN looks at it, our current attrition rate that we watch is 100% on-time completion. And so that means if you have 10 students that enroll and they're supposed to be done in 2 years, we want to see of those 10 specific students that enrolled, which ones completed at exactly the 2-year mark. Our BRN standards are higher when looking at that. Then even past that, when you look at the makeup of our schools in California, 91 of our 156 schools are associate degree in nursing programs, and only 64 of the 91 are not accredited. So it does not serve the associate degree nursing programs to give them an exemption. It does not differentiate that way. And when the majority of our schools wouldn't even benefit from this, that kind of brings me to an area of concern. The other things that go in there, and again, I understand why they are asking for this. It says that they should notify the board of any substantive changes or other changes as defined by the board regulations and national regional accreditors. Substantive changes as defined in our law is under that one of our regulations that is currently with OAL that talk about new campus locations, that talk about new enrollment increases, that talk about a change to the approved program, that maybe it's a change in ownership. Those are a lot of things that we consider substantive changes. This would require them only to notify us, the board, not to get approval of. So they can open a new campus, they can move the school completely to a different location, they could sell the school to a different person, they could increase their enrollment, and the board would not approve that. We would just be notified that it occurred. Some of those areas of great public concern come with what happened a few years ago when a large school in Southern California closed. Students showed up and they were said, go home, we're closed. And that is because of a funding change after a school had changed ownership. And so they were not able to do financial aid, and they closed, and we had 180 students that needed to have a program pick them up, and Glendale Career College did, and that was wonderful. But that was a public protection issue that came up. When a feasibility study is put in front of our board and you guys approve that for a new program, it studies the area that they say that they're going to be located in. So when you guys are looking at regional impact and you say, you know, in Kern County, we definitely need a nursing program. And so I can tell you that Saracosa College has submitted that they want to do a letter of intent. So Saracosa College would say, I want a school here. This is the demographic I'm going to serve. These are the resources that I have. And this is why the board should approve me for that area. Wonderful. There's a need. There's absolutely a need in that area. There's a workforce need. There's clinical facilities to support it. An approval could occur if the board voted for that. If later on you decide to change location, which is a substantive change, and just notify us, you could say, well, you know, I don't want to do this at Saracosa College anymore. Saracosa College is going to stop their RN program in Ridgecrest, China Lake. They're actually going to open that up in San Diego County. Well, and we would just notify the board that. Well, okay, that could happen, but we know that there's clinical impaction in San Diego County, and we know that it would have a big effect if that location was now there. And that is, again, why the board is part of the approval process if they want to change location, if they want to change ownership, if they want to add a new campus. And so that there ties into that greatly. Another area where it talks about in that bill, it talks about that they don't want to get approval of faculty. I understand that. That has been an incredibly cumbersome process. But as of this morning, we have a brand new process because, again, at the sunset hearing a year ago, we started action on this. That brand new process for faculty is we now mirror the teaching credentialing board. We do a preliminary credentialing essentially by giving an assistant instructor approval, and then we can move them to a full instructor approval, and that would be like your full teaching credential. That is where we're in alignment. Previously, and why they wanted to address this is you had to get a faculty approval no matter what school you went to teach at, no matter how many times. I can be hired at 3 schools within 2 weeks, and each one of those schools would have had to contact the board and get approval to hire and approve them as a faculty member for that school. That was the redundancy that was noticed, and we made changes. So you only need a one-time approval that is now tied to the BRN license Breeze system, and today is when it is going live. So you're not going to see anything today, but it is live today, and any faculty approval that comes to our NECs today will get put onto Breeze and will be tied to the license lookup. We do have a patch in process that is pulling all of the previous data, and we will get that added to Breeze ASAP so that they don't. Now the school, all they have to do when they verify license of the person that they want to hire, will see that they have a faculty approval. They will not need to seek additional faculty approval from the board anymore. So we've already, again, answered this by making those improvements, getting that technology built and in place, and we're building that system today now that it has gone live. When it talks about clinical simulations hours in a skills lab, up to 50% of the total number of clinical hours, what happens here is that we already have a board motion that was put into place in November last year, where you guys said we need to establish a direct patient care requirement and not a percentage any further. And so we have NEWAC that hopefully we'll be able to have a first meeting within a month or two here. And they will start to work on that, establishing a minimum direct patient care requirement, because part of that simulation study that NCSBN released said in order to implement it, and this again is all in our background response paper, you have to establish a minimum direct patient care. Well, the board had never done that. So we want to move to allow the schools to have that independence to be able to do as many simulation hours as they choose after the direct patient care requirement is met. So this again would go in opposition of where we already voted as a board to move forward to establish a minimum direct patient care requirement so that we can effectively implement a higher simulation in California. Then D and E of the new bill talks about clinical experience placements at a clinical agency or facility that is already approved by the board. That's absolutely where we're going. And this is where it correlates with the regulatory update we just had at the beginning of our board meeting here that you guys voted to accept. It also correlates with the passing of AB 1015, which is now 2017 of our BPC, where the same person that introduced this bill passed that bill, Rubio, and it would require it would create a duplicity. Sorry, I'm stumbling in my words here. So what happens here right now is our current process is they approve the clinical facility. We put it into this data bank. Once that data bank goes live on our website, which it should by the end of this year, it has all of that and it creates a transparency. We pull that data and that's going to help us with the workforce data and everything that Rubio wrote in an AB 1015 that became BPC 2717. So we can get that clinical information, tie it to OSHPD and HCI, tie it to CDPH, get all that stuff out there. This here says that they don't have to seek approval, but it doesn't null and void that additional request from BPC 2717, which still would have them give us all of that same information that they would have given us on an approval and give it to us so we can have a part of that data bank. And so the other thing that it changes is on here, it says that the facility of the exempt school or program attest under penalty of perjury that the new clinical placements will not displace parties that are in compliance with this. That's a huge change. And I wanted to call that out because right now in our regulations, which is 1427, the statement that we have says in selecting a new clinical agency or facility for student placement, the program shall take into consideration the impact that an additional group of students would have on a student of another nursing program already assigned to the agency or facility. We have difficulties with clinical facilities wanting to even attest to that they've taken into consideration, not attest under penalty of perjury that they couldn't go forward that. So again, two-tiered system where they would probably want to go to the lesser requirement that BRN has versus going to that. Additionally, when they're addressing the clinical facilities, what they're not addressing is the contracting part. BRN has something in 1427 clinical facilities that each such program shall maintain written agreements with such facilities and such agreements shall include. Those written agreements are contracts. An assurance of the availability and appropriateness of the learning environment in relation to the program's written objectives. The provision for orientation of faculty and students. A specification of the responsibility and authority of the facility staff as related to the program and to educational experiences of the student. Assurance that the staff is adequate in number and quality to ensure safe and continuous healthcare services to patients, which means don't include the students as part of your staffing ratio. Provisions for continuing communication between facility and the program, and a description of the responsibilities of faculty assigned to the facilities utilized by the program. So those are safety measures that are part of our clinical facilities. And that is something that is not addressed in this bill that could cause, again, a two-tiered system. The next part that I want to bring attention to this is the faculty part, where they didn't want the faculty part of that. That's part of our resources that we evaluate on continuing approval. And I'm sure you guys remember at the previous board meeting, there was identification that there were several schools that didn't have the appropriate faculty resources to continue to assist the student load that they were taking in right now. And we had campus administration on the meeting with us. And we asked about the hiring process. And they talked about the hiring process. But then because the BRN has this authority for faculty and assuring resources, we were able to say, what is their priority in hiring? And that is when the dean and the president said, we will make this a high priority for hiring. This is something that many of our schools rely upon because they're not able to get high priority placements for faculty positions. It goes into the general pool with everybody else in that college or university. And so this would be seen as a detriment to our colleges that really utilize that to be able to get faculty to come in and support their enrollment numbers. Because again, you need clinicals, you need faculty, you need those resources in order to support the students that are enrolled, and those are those enrollment increases. So there really is a fiscal impact aligned with this. There's additional workload, which was not the intent, because Senator Roth kept saying we need to take some of the responsibilities away from the NECs. We're really working on doing that currently with the board, where we decreased our visits to align with the accreditors. We stopped requiring an additional application or report. We're only accepting the ones that is part of the accreditors. This bill has us doing a separate application and report to show that they've met those additional requirements. So it doesn't take that away. And it does, what happens if at some point in this cycle, you fall out of that 80%, well, then you go back into the other tier. We would have to realign them with that other tier, put them into our system. So there's a lot of issues with the way that this bill is presented that would increase the fiscal impact, increase the workload, not have a clear idea of how you bounce back and forth. I understand that if this bill doesn't go through this year, that it'll come back in several different changes. But I think as we provide these input that, you know, Imelda had and that you've had now, Mary, as well, that it will help this bill to become a better bill so that maybe in the future it could be implemented. But I don't see how it truly serves the intent of the bill the way that it's written right now.
I mean, it seems a lot of things in the bill we're already trying to do or doing.
Yes, we really took it to heart. It's part of our strategic plan that you guys were approved. It's part of our sunset reports. When this was brought to us last year, we did a work group on this, and we have made several changes, and they're just now starting to come to fruition. We had our first combined meeting in the fall of last year, and I think we've had 4 or 5 since then, getting a lot of really good feedback, streamlining that, and not requiring additional reporting. And then now the facility thing will be going online this year, so that will be a less cumbersome process. And once that facility is approved, the school will not have to seek additional approval because the board has already approved it. So that what they're kind of on there that they wrote into D and E is already addressed. The faculty that they put into 4A already addressed as of today. It will be tiered with our Breeze license lookup, and that will become more and more robust, and people will have those one-time approvals unless we need to level them different as a request by them. And that it's really just a good processes that we put in place that we're in collaboration with our deans and directors in a work group. So hoping to address this bill and improvements that we've already made, and we're on a really good path here.
Thank you, Lori. Any other questions or comments from the board? I believe we have a motion on the floor.
I believe Imelda did a motion to oppose. Was that correct, Imelda?
She's not there.
Second.
I'm sorry, I am. I didn't make a motion to oppose, and I think.
I seconded it.
Okay, thank you.
Great, thank you very much.
I find it interesting. The bill is doing 2 things, and I could see how they're kind of sort of related, but in a way, the second thing is almost its own separate, unrelated thing. One is, you know, dealing with the exempt nursing schools. The other is prohibiting any higher education or private post-secondary school of nursing from making payment to any clinical agency or facility in exchange for clinical experience placements. I can see how that kind of ties in a little bit to, you know, the exempt nursing school issue if you're going to be creating that other tier. But it's also, it seems to kind of stand alone as its own thing, preventing these payments for clinical spots. I'm just curious if there happen to be any thoughts. If not, fine. If if the position of opposition is primarily to the creation of these exempt nursing schools, or the bill in its entirety, which includes that piece about prohibiting payment for clinical facilities.
So I'm sorry, and thank you, Reza, for bringing that up. The prohibiting the payment, and so that to me is again an issue that needs to be kind of flushed out a little bit more. There are only a few, and we did receive some copies of some smaller community-based clinics that do require payment, and I'll explain why they require payment. PPE, that was a big thing that came in with COVID. If you get a physician's office that will be taking care of students, and they ask for the school to give them some money for this clinical placement, and that is to help them recoup the supplies that they are utilizing by having the clinical group there. Pay back for the gloves and the extra mask and the extra supplies that needed to be there to have 2 or 3 more people into their office that they hadn't supplied for. So there are some legitimate reasons when these clinical groups, clinical facilities say, I need you to pay to have your students here, and that is to recoup some cost. There are more areas as well that become an issue of public protection where we sit there and go, wait a minute, you're paying for a clinical site there and you're kicking out other schools that refuse to pay to go there. That is, I'm assuming, what they're trying to address here. But again, when you make a broad sweeping example of that, it kicks out some of these community-based areas that our schools are moving to have a more diverse experience and to assist with the clinical impaction. The other thing that comes up to this is, how do we track this? How do we know that there are payments being received by a facility or a school? They would have to be able to tell us. There's no tracking ability of that to get primary source data. It would be word of mouth. And some of the things that we have heard is that some organizations will give a donation to the fund, and then that donation to the fund, they then get these perks, and there's no tie to that. So it's not like they're paying per a contract that says, you give us this much, we will give you a clinical placement. The other thing that comes in as issue here is and I completely blanked on that. I'm so sorry, guys. But those were some of the big things. So the legit clinical agencies that say, hey, pay for the additional resources that you'll be using at my clinic, and I will support your clinical group. Absolutely fabulous. There are some that use that as I will pay to get in here, and I have the ability to pay, because I can tell you a lot of our community colleges, because they're state funded, do not have an additional way to pay for those. Here's the one that I was thinking, and I'm sorry, thank you. They make relationship agreements. So it's not necessary pay, but it's a relationship agreement that says, we will educate your current employees in turn for using your site as a clinical placement. That's not necessarily a payment, but that does have an impact on the clinicals in that area, because they now have employees at the facility getting a discounted rate to go to that school, where they can do an LVN to RN, or they can do a CNA to an RN, or they can do any other courses that are offered at that school in exchange for a discounted rate to their employees, by allowing them to do their clinical rotations at that place that they're employed. So I understand the intent of this. There's a lot more work that needs to be done in order for that to be something that we can carry out to effectively address the problem that's being brought in front of us. So hopefully that helped to answer your question, Reza, and show that it's much more widespread. And sometimes payment for clinicals is absolutely appropriate when it's to reimburse for the supplies that the clinical group will be utilizing by going there. There's many times where they're required to bring equipment or reimburse for the equipment that is used by the clinical group at those sites.
So, I mean, those are good points, and I appreciate your insight. Obviously, you've got great insight on this. Do you think that, I mean, the wording of the proposed statute says shall not make a payment to any clinical agency or facility in exchange for clinical experience placements. So I think, first of all, that could be construed as like being limited to these kind of quid pro quo setups where, the school pays the facility gives clinical placement slots, and, certain types of other payments wouldn't necessarily fit into that. It could also be interpreted more broadly. Also, subdivision C of that 2786.4 carves out certain types of payments that wouldn't be a violation. It says for purposes of payment of pass-through fees for purposes of credentialing, data bank registration, or similar fees shall not constitute a violation. So I'm wondering, Lori, again, with all of your insight, do you think it would be, would you recommend to the board there's just too many problems with that section as a whole, or could that section be reworked by either expanding the categories of carve-outs in subdivision C that are defined as not a violation, or just kind of spelling out a little bit more what type of payment is a violation, or some way of modifying it to get at this issue of addressing the types of payments that seem to be maybe unfairly tilting the playing field?
I think, again, I think that the intention is appropriate. I think there's way too much work to address it in just a simple revision at this point. To do a specific call out, I understand the credentialing, I understand the data bank registration. Similar fees does not say something like I need $500 per student to come here to supplement the supply costs that I have. And then it says, and then how do you address the ones that donate to a fund or have an LLC that's not tied to them that donate to a fund that then ties them back, or they sit on the same board and to a local hospital. So there's hospitals that have boards that oversee them. And somebody that works at this school makes a deal with that board member, or how do you include tuition reduction as part of that when you really want to improve the excuse me, the education of our healthcare workers to go from ADN to BSN. We specifically have that in our business professions code to encourage those collaborations to go from ADN to BSN. And part of that encouragement could be tuition reimbursement or a decreased tuition. And a lot of our private colleges really stepped up for that and said, hey, yes, I'm going to partner with this community college. I want to give that tuition reduction. I'm going to do a BSN, an ADN to BSN. And they really stood up for that. But then you can have to trace back through something that maybe there was also an agreement with a facility. We had a enrollment increase that came from our board, I believe last year, which was GCC, that said, we've partnered with Grossmont Hospital, Sharp Healthcare, and they want us to provide education to their students in turn for decreased tuition, and we would do it through an agreement at this site. Well, that to me, when you look at that at face value, it sounds wonderful. But then when you take a deeper look into that, you start to go, okay, well, there's already students enrolled at that clinical facility. And although this is not a direct payment, that can't be seen as you made a payment to this school, there was a financial agreement, there was a contract established. How would you do a carve out for that? So again, I think that this is absolutely a wonderful intent. I think that stopping these payment for placements process is absolutely appropriate. I don't think that it's at a point to do this right now. And so that was just to answer your question without Reza. I think with some work, this bill could be effective. I think it's going to take a lot of conversation, a lot of work with that. And I think in the current state right now, Imelda and Dolores's position of oppose makes sense.
Any other questions or comments from the board? All right, Capri. We have a first and a second. We can move on.
Sure, yeah, absolutely. So AB 2684 is the next bill, and this is the BRN Sunset Extension Bill pertaining currently to Board of Registered Nurses removal of member. That's the current language, the current title of the bill, but it is this will be the BRN Sunset Extension vehicle. So that language has not yet been added, and however, the sunset hearing was completed on Friday, this last Friday, March 18th. What this bill currently is doing, it's rescinding the governor's power to remove any member of the Board of Registered Nurses, registered nursing for cause, except for those members appointed by the governor, as well as some other non-substantive changes at this time. And it is scheduled for a hearing on April 26th in the Assembly Committee on Business and Professions. So that language should be forthcoming. It should be, we should be getting that soon. The sunset extension language, as well as maybe anything additional or anything else that they wish to add. That they can do that as well.
So we have about a month where we hold our breath. Is that correct, Capri? To see what kind of a sunset extension we get?
It might be sooner. It might be sooner. We don't know. Yeah.
Perfect. Thank you so much.
If we were to take a watch position on this bill, is there a way for us to do a quick huddle once the language gets placed into the bill and we could then, evaluate a
So,
position?
because that would be a change, right? It would be an addition.
It would be a change. We would have to notice a board meeting. It would not be a quick huddle. We would do a board meeting. We would have to have a quorum. We would do a 10-day notice, and then we would have to go out and change our position. We do have time to do that. We do have a meeting scheduled for May, which is a in-person board meeting currently. So we could do that. That would be after the April 26th. So if we needed to have a meeting prior to April 26th, we would have to do a 10-day notice, put out an agenda, put materials up, and then establish a quorum. Unless, Reza, you think there's any other way that we could delegate a position to the admin committee if the bill changes with any substantive language or something to that effect. I can't think of anything, but I'll open it up to you for any ideas, Reza.
I was kind of caught in the middle of switching headsets here. So can you just reiterate what's the question?
Not a problem. Tricia was thinking we could take a watch position, but then the concern is if in the next month before it goes to hearing on the 26th, we don't have a board meeting scheduled, they introduce some language that is absolutely catastrophic to the board where we need to take a position of oppose. And so would we have to notice a separate board meeting, do the 10-day posting, get agenda, materials, and get a quorum to change that position? Or is there a way that the board could vote right here to delegate authority to the admin committee to do a change in status if something were to come up? I don't know of anything of that. And so that is why I then opened it up to you, because my understanding, we would have to notice a board meeting if we wanted to change a position on a bill or anything, but you might have an alternate route that you can share with us.
Got it. Thank you. Again, sorry about that. So I think, yeah, most likely you'd have to notice a board meeting, because ultimately when we communicate our position on it, we're communicating the board's position. And so it ought to be the board, speaking to what its position is. I think the one thing that comes to mind is if you anticipate some possible change, or you can think of some specific change that you could identify today that you say, if this change is made, then we would change our position. So if this is added to the bill, or if this is removed from the bill, then we would change our position. And if you can kind of specifically identify what that is and vote on it today, I think you could, that would allow for the board to change whatever position it adopts today without
coming back to another board meeting. Short of that, if you know, if you just want to delegate authority to the admin committee to consider any change to the bill and consider what the position of the entire board ought to be, I think that might be going a little bit far. I wouldn't say that you necessarily can't do it, but it's I think then communicating something to the legislature that this is, you know, a new position of the board, when in fact it's the board itself hasn't really considered or discussed it as a whole. So my suggestion would be either come back for a full board meeting, or if there are very specific things that you can identify today that would trigger a change in the position that you adopt today, you can lay those out. I'm not sure whether that's something that's possible or not here, but I would stick to that at the most.
So we have another board meeting in May, right? An in-person board meeting.
That is correct. Currently scheduled a board meeting in May, which is after this goes to committee on the 26th of April.
So the statement on here rescinds the governor's power to remove any member of the Board of Registered Nurses for cause. Can you explain that sentence to me a little more, Reza, and what that means?
So while Rez is
Yes,
pulling that up, I can talk about it a little bit. Currently, the governor holds the right in our business profession code to remove any of the 9 members.
Yes.
What this does right now is it can remove 7 of our 9 members. He or she cannot remove a member appointed by the Senate or the member appointed by the Assembly. That is what the change is to this right now, is my understanding.
That's right. So the governor would be able to remove his or her appointees, and the other appointing powers would be able to remove their appointees. And the phrase "for cause" refers to the current language in statute in section 2706 that reads, "For neglect of any duty required by law, or for incompetency or unprofessional or dishonorable conduct." So those under the current law, the governor can remove any member of the board from office for any of those things, neglect of duty, etc. And this would just give the governor and the other appointing powers authority over their own appointees and not the other board members.
I can't think of any reason we wouldn't want to just watch this, since we know it's
Yeah.
gonna change, right?
I agree.
Yes, I'll make a motion that we watch this.
I'll second that, Woods.
Thank you.
All right, moving on to the next one, AB 2694 Rubio, nursing schools. This is still a placeholder bill, a spot bill with substantive language awaited. No current impact on this bill. So the next one is AB 2948, Cooper, Assemblyman Cooper, Consumer Protection. This bill, as per the author's office, will not advance and is, it is really dead at this point. So that will be removed from our list. Going on to SB 889, Oshawa Bogue, nurse anesthetists. The board took a watch position on this bill at the last meeting, and so I did want to just clarify that since then we've had a chance to look at it as far as the fiscal impact, and what this bill will be doing is allowing a certified registered nurse anesthetist to hold their own permit to provide general anesthesia and deep sedation in a dental office. If dentists chose to have an anesthesia provider in their practice, this permit allows all anesthesia professionals in California to hold their own permit. with provider scarcity. This is actually what what I'm sharing with you. Since I did provide a summary last time, this is really what the author is saying as far as in their advocacy for this bill, is that with provider scarcity in medically underserved areas in California, this increases the options available for a dentist to utilize all anesthesia professionals and expand dental care in California. Many Californians need dental care, and those dentists who desire anesthesia services from a CRNA can do so without the regulatory burden of obtaining a permit themselves. And this bill will expand access to care while also providing safety for each procedure performed. And peer-reviewed studies have shown that CRNAs provide a safe, effective, and necessary service to their patients. The author believes that nurse anesthetists should be able to obtain their own permits for the care that they provide. And this bill is scheduled for hearing on April 18th in the Senate Committee on Business Professions and Economic Development.
A watch position, but there was based on additional information that was requested by the board, and then wanted to see how this would affect kind of the enforcement. So I did meet with enforcement. We kind of talked about it. There were a couple things that they shared with me that would be benefits, and that would be if they had an MOU with the dental board and us, and then if we maintained a listing. We did reach out to the sponsor of the bill and let them know that these were some of the asks from our enforcement that would make this really easily for us to implement. And they took that into consideration. I think there will be some amendments coming forward that would talk about potentially adding that an MOU between dental board and BRN would be maintained, and that we'd have a listing. The reason that speaking to our enforcement chief gave behind that was that if we had a listing of each one of the CRNAs that hold this permit, if there was anything that was brought against that CRNA to us, we would then know to notify dental board so that they can investigate and see if there's anything that goes against the permitting process, and vice versa. If the dental board received a complaint against the permit, they would then let us know regarding the CRNA. So that we can join that investigation as well, and nothing would get missed. And so that would be why the MOU and why the listing. Just to reiterate, this is a bill that expands service, and it does not change the current scope of practice for our nurse anesthetists. They do provide anesthesia services in dental offices to these patients. And it doesn't change that, and it is supported within our NPA to do that. The change that does come is through the dental board, not through BRN, and it allows for the CRNA to hold the permit versus the dentist to hold the permit. And so just an ask to you guys to see if we want to continue watch or move to a different position, either support or oppose.
I would like to make a motion to support. Do I have a second?
Jovita seconds.
Thank you, Jovita.
Moving on to the next one, Senate Bill 1031, Oshoa Bogue, Healing Arts Board's inactive license fees. This bill will require that the renewal fee for an inactive license to be half of the amount of the fee for renewal of an active license, unless the board establishes a lower fee. The intent behind this is to reduce inactive license fees. You know, that in what it will do is provide licensees with financial relief and flexibility. It will also incentivize individuals who choose to take a temporary pause, in their profession, to go on inactive status rather than become delinquent or have a retired status, which makes it easier for them to transition back to an active status. So the fiscal impact that we were able to determine on this one is an estimated loss of revenue to the BRN per year of about $1 million, $1,054,000. And it is scheduled for hearing on April 18th in the Senate Committee on Business Professions, Economic Development.
Any questions or comments from the board?
Is it less, challenging, or is it less workload in doing an inactive license versus a regular license?
The
So
workload.
I could speak to that. The great thing is I believe by the end of this fiscal year, this will be an automated process, where a person would apply from an inactive to an active status online, pay the fee, and they attest to the CEUs. The system checks for fingerprints and will automatically make them licensed in an active status. So it will not delay going from inactive to active, and it doesn't necessarily affect a workload once that becomes automated. And the releases that we have scheduled for the IT on that are scheduled to be done hopefully by the end of this fiscal year. So the hope is that this will become automated after June. But it's something that our board has the ability to support. It's an easy process, and the intent is to automate it. And so it should be fairly easy for them to go back and forth. When you look at the person that is applying for this, it's a process within Breeze. They go onto Breeze and they go to renew, and you can renew to an inactive status or renew to an active status. And so that there is already part of that too.
One of the things that I think, if to the extent that having to renew, that the expense of an inactive renewal is keeping people from doing that and letting their license lapse. I know we had some people who had retired and decided because of the expense not to keep their license active. And then with COVID, they wanted to come back and help, and they had let their license lapse. So if this would indeed encourage people to maintain a license, and if they ever did want to come back, I would support it.
Yeah, that actually was part of the intent there. And then really just to understand, when you guys look at fees, the license, when you renew, those renewal fees go to support the enforcement activities, the majority of them. That's why those fees are associated to the renewal of the license. So if you renew to an active license, it would make sense that that has a higher fee attached to it, because you're paying for the enforcement that could potentially come by having that license. If you renew to an inactive status, you were supposed to be inactive, you're not supposed to be practicing, there should not be incurring any kind of enforcement fees or anything with that. We do have in regulation right now, one of the cleanups is we will be creating a retired license status. And we will be working on that and moving it through the regulatory process in the next few years. And so that will also help with what the example that you gave, Mary, where people want to retire, but they don't want to leave their license. And so they can go to a retired status. That is not intended to be as simple as going from inactive to active. But we do have the inactive to active process right now. We are automating it, and the increased fees for the active license is for enforcement. Now, the caveat to that is if they go to inactive and they continue to work on that license, and that would be problematic because of course there would be some enforcement issues, but I do hope that the facilities that are hiring them do their due diligence, which is what they're supposed to do on any hire, where you pull up Breeze, you look that that person is current, is unencumbered, and has an active license. So I don't foresee that that practice would occur on an inactive license if the facilities that are hiring them were to follow that. So.
Comments? Anybody like to make a motion?
Approval of supporting this bill.
This is Mary. I second that.
Thank you.
All right, moving on to the next one. That is Senate Bill 1237, Senator Newman's bill licenses military service. This bill will require DCA boards to waive the renewal fee of any licensee or registrant who's called to active duty as a member of the armed forces or California National Guard if the licensee or registrant is stationed outside of California. It is this bill is in its current form. This is really law at the moment, but what the intent is to expand eligibility for the renewal fee waiver established by BPC section 114.3 to include members of the military serving at military installations on a non-temporary basis, or those serving on in a career or permanent assignment. So because currently that's how DCA construes this, they have that listed on the website, which is that active duty is really on a temporary basis. So this wants to clarify this, and they'll be adding amendments that's expected to clarify that active duty members receive fee and any other applicable waivers, irrespective of service length or location, as long as they're in active duty. So that's what this bill wants to do. Its fiscal impact is there is none on the BRN because the BRN does offer fee and other eligible waivers to active duty personnel irrespective of service length or location. So this is in the Senate Committee on Business Professions at this time.
BRN already does this, so there would be no fiscal impact to us.
I'd like to make a motion to support.
And
Okay. All right, moving on then to SB 1365, Senator Jones' bill, licensing boards procedures. This bill will require each board within the DCA to publicly post on its internet website a list of criteria used to evaluate applicants with criminal convictions so that potential applicants for licensure may be better informed about their possibilities of gaining licensure before investing time and resources into education, training, and application fees. The bill will require DCA to establish a process to assist each board in developing its internet website as specified. Again, at the other provision applying to DCA to develop a process for each board to use in verifying applicant information and performing background checks of applicants, and would require that process to, for applicants with convictions to provide certified court documents instead of listing convictions on application documents. The bill further requires the board to develop a procedure to provide for an informal appeals process that would occur between an initial license denial and an administrative law hearing. And the intent behind this is, by streamlining the current process and providing accurate information on online platforms, the application will be more straightforward and accessible to all Californians. It will also give formerly incarcerated people all the necessary information to decide whether to invest their time and money to apply for a license. The fiscal impact involved is substantial. It will require over 300 hours of staff work at various analyst and management levels. So that's something to consider. And then the status of the bill is it's scheduled for a hearing on April 4th in the Senate Committee on Business Professions. You might have noticed it is something similar to, similar to AB 1662, which was asking for, at the pre-application, pre-licensure stage for applicants, potential applicants, considering, maybe a nursing school or to becoming, considering becoming nurses, to contact the BRN to maybe get that information about if they have charges, convictions in their background. This bill is going to have the board, put information on the website with things which might make someone ineligible for licensure. So it's something similar. It's not something that that we're potential applicants are reaching out to the board. It's something that the board would have to do by putting this information on the website.
And so just to clarify, we have a lot of information on our website. This would be an easy one for our board to implement. It would truly help. We do have, if you go into our website and type in enforcement, it pulls up the enforcement program. you're able to read what the enforcement program is. There is an applicant enforcement webinar that was recorded that an applicant can watch, learn all the things that they would need, what is looked at. There's an enforcement frequently asked question regarding what type of complaints, drug and alcohol abuse, gross negligence, etc. And so additionally, because our disciplinary guidelines are in regulations, all of our disciplinary guidelines are public knowledge as well. So we have a really good start to this already. It is clear, it is on our website, but we could put it in a more concise location, draw some attention to it, say, hey, if you're interested in nursing school, please watch this first, that kind of stuff, so we can do some improvements. But our board is already well on the way to this. We've been commended at the applicant and the enforcement information we have on our website, and we could just continue to streamline that process. But we're well on our way with this already.
Any comments or questions from the board?
And quickly, just to point out that exactly as Lori said, that's the website provision. The other provision does relate to an informal appeals board. That is which has about 300 hours of staff work, about 200 and something, with a total of 300 some hours of staff work. So that component will require some additional workload for the informal appeals process to be set up.
Is there any opposition to this bill?
It's there. We don't have an analysis committee analysis posted by the committee, so I don't have that information just yet, Imelda.
We should support this.
Is that your motion, Betty?
Yes, it is.
Thank you.
Mary, I'll second.
Thank you.
All right, moving on to SB 1375 Atkins, nurse practitioners. This bill will allow a nurse practitioner practicing pursuant to a standardized procedure, a qualified nurse practitioner functioning pursuant to section 2837.103 or 2837.104, that is 103 and 104 NPs, to perform an abortion by aspiration technique pursuant to section 2253 upon completing training recognized by the Board of Registered Nursing. And it does not apply, it does not apply subsection B of the BPC section 2725 to 103 and 104 NPs, which pertains to physician supervision, assistance, consultation. So that's kind of aligning that with what it was in, for 103, 104 NPs as per AB 890 from a couple of years ago, which is being implemented now. It removes.
Yeah, so just to interrupt really quick, Gurpreet, we'll address this section before we go to the second part of this bill. This was a cleanup bill, and what was noticed is in our current business professions codes, it allows for nurse practitioners or nurse midwives to do abortive procedures under standardized procedures. And that is a specific carve out that actually says in that business profession code, separate from what was updated with AB 890 and SB 1237, that it has to be with standardized procedures. So this bill, essentially this section of this bill removes that standardized procedure requirement for the 103 and 104 NPs, because 103 and 104 NPs do not have to work under standardized procedures. And so it allows for the continued scope of practice. It allows for everything to kind of go smoothly. And it is a cleanup that was specifically related to the passing of AB 890 when it created 103 and 104 NPs who can do these things without standardized procedures. So that part of the bill is very straightforward. And I'll let Gurpreet move on to the second part of the bill that has been updated.
Sure, and exactly, it is a cleanup bill, partly of AB 890, and it removes the requirement that of AB 890 that the BRN shall, by regulation, define minimum standards for transition to practice, and that clinical experience may include experience obtained before January 1st, 2021, if the experience meets the requirements established by the board. Instead, it requires that a nurse practitioner who has been practicing a minimum of 3 full-time equivalent years of that or 4,600 hours as of January 1st, 2023, shall satisfy the transition to practice requirement. And clinical experience may include experience obtained before January 1st, 2023, and be counted towards the 3 full-time equivalent years or 4,600 hours. And lastly, it also updates section 123.468B1 and 2 with nurse practitioner and certified nurse midwife additions as per AB 890 again. So the intent, what is behind this really is that it increases access and affordability in healthcare and abortion services for all Californians. Specifically, the bill would make necessary clarifications to existing law that allows nurse practitioners that meet specified criteria to practice independently without physician supervision, and also addresses the shortage of healthcare professionals able to provide early abortion care by allowing NPs authorized to practice independently to provide first trimester abortion care without physician supervision. And it will clarify that NPs who have been practicing for 3 or more years satisfy the transition to practice requirement established in AB 890, and also allows NPs to utilize prior practice experience to satisfy the TTP, the transition to practice. So that's the intent of this bill. It is currently in the Senate Committee on Business Professions, Economic Development, and the author is the Senate Pro Tem. And the principal co-author is Assemblyman Wood, who authored AB 890 and AB 852, which is currently active, is proceeding as well, which is the cleanup bill for AB 890 as well.
This
Support the intent of this bill, but I don't have enough experience to really know whether this is good precedent or whether this has occurred in other practices. So I would really benefit from listening to you all kind of give your thoughts.
This is Betty, and I have a question. This essentially would not require a nurse practitioner to be under the 103 and 104. Is that my understanding?
Not require what, Betty? You cut out because you kind of turned away from your speaker.
Yeah, because I'm trying to read the bill while I'm talking. This would do away with the section that nurse practitioners had to be a nurse practitioner 103 or a 104. Is that my understanding of this?
So no, we would still have a 103 and a 104 section. We would have a changed ability to get to the 103 and 104. It addresses the transition of practice, which is what is used to go from a nurse practitioner that's operating under standardized procedures to a nurse practitioner that does not have to operate under standardized procedures within a healthcare facility. So it does not address the nurse practitioner that is independent without standardized procedures that can have a private practice.
I'm still unclear about the ability of a nurse practitioner to be qualified to do the abortion, but not be the 103 and 104.
Let me help you with that. We have a current business and professions code that gives that authority to, nurse practitioners to perform abortion with specified training. Find it here. So it's 2725.4. This is our current business professions code. And it says, notwithstanding any other provisions of the chapter, the following shall apply. In order to perform an abortion by aspiration techniques pursuant to section 2253, a person with a license or certificate to practice as a nurse practitioner or a certified nurse midwife shall complete training recognized by the Board of Registered Nursing. Beginning January 1, 2014, and until January 1, 2016, the competency-based training protocols established by Health Workforce Pilot Project HWPP number 171 through the Office of Statewide Planning, Health Planning and Development shall be used. In order to perform an abortion by aspiration technique pursuant to section 2253, a person with a license or certificate to practice as a nurse practitioner or a certified nurse midwife shall adhere to standardized procedures developed in compliance with subdivision C of section 2725 that specify all of the following: extent of supervision by a physician and surgeon with relevant training and expertise, procedures for transferring patients to the care of the physician and surgeon or hospital, procedure for obtaining assistance and consultation from a physician or surgeon, procedures for providing emergency care until the physician assistance and consultation are available, the method of periodic review of the provisions of the standard procedures. A nurse practitioner or certified nurse midwife who has completed training and achieved clinical competency through HWPP number 171 shall be authorized to perform aborts by aspiration techniques pursuant to section 2253 in adherence to standardized procedure described in the subdivision. It is unprofessional conduct for any nurse practitioner or certified nurse midwife to perform an abortion by aspiration technique pursuant to 2253 without prior completing of training and validation of clinical competency. So this is what we already have, and this has been in our statute since 2013. When AB 890 passed, it removed the ability to have standardized procedures for the 103 and the 104 NP. This would, if not updated, hinder the 103 and the 104 NP to be able to perform these abortions without standardized procedures. They would have to go back, do that procedure, only that procedure, specifically under standardized procedures with a physician oversight. So it would essentially kind of remove some of the independence that they got from going to a 103 and 104 if this statute stayed current in its the way that it's written, with the requirement specifically stated in there that they have to have standardized procedures. So this is a cleanup bill to keep the standardized procedure process that's always been in place since 2013, but remove the standardized procedure process for the 103 and the 104 NPs because they do not require standardized procedures any further.
Thank you for that clarification.
I'd like
You're
to
welcome.
support this bill.
I'll second it. This is Dolores.
Right, moving on to the next one here. Senate Bill 1424. This one, no current impact, placeholder bill, no substantive language added just yet. So I'll be keeping an eye on this one. And SB 1451, again, no current impact, no substantive language on this one either. Moving on to indirect impact bills, AB 1810, Levine, pupil health, seizure disorders. So this is a bill that creates the Seizure Safe Schools Act. It is substantively similar to, Education Code Section 49414.7, which were self-repealed on January 1st, 2017. So and what this bill is doing is it's on a parent's or guardian's request will allow a volunteer who is a school employee and who has received training to administer emergency anti-seizure medication to a pupil diagnosed with seizures, a seizure disorder, or epilepsy if the pupil is suffering from a seizure and a school nurse is not available. So it requires that the parent guardian to provide a seizure action plan to the school and is along the lines of the now repealed Education Code 49414.7. In that regard, it's a written statement from the pupil's healthcare provider is required that includes information such as a name and purpose of the medication, prescribed dosage, method of administration, etc. Both this bill and the earlier law outline the training to be provided to the volunteers administering the emergency anti-seizure medication. And the earlier statute noted that an emergency anti-seizure medication means diazepam, rectal gel, and emergency medications approved by the FDA for patients with epilepsy for the management of seizures. This bill requires that the emergency anti-seizure medication or medication prescribed to a pupil to treat the pupil's seizures, a seizure disorder or epilepsy symptoms shall be provided to the school with a label affixed by the dispensing pharmacy intact, and this medication will be stored at the school. So the intent here is that it is important that those who are supervising a child with epilepsy have the opportunity to be trained properly, to recognize and if necessary to respond to a seizure and help the child. While school nurses are trained to administer medication, school nurses may not be on site or available when a seizure occurs. So this bill was amended on March 14th recently, but I did cover those within the provisions that I shared with you, and it's scheduled for a hearing on March 23rd. Was scheduled yesterday, so so it's moving forward. That's what was going on with this one. Your questions on this bill?
Just pretty clear. It just kind of highlights, it refines the bill that was already passed and put into law in 2011 that repealed itself in 2017. There was another bill that kind of carried some of those provisions, but it wasn't as clear. And so this is just kind of re-clarifying, putting those provisions out in more specificity, and allowing for that care to be continued to be provided to the student.
This is Mary. I'd like to move to support this bill.
Thank you.
Okay, all right, great, thank you. And then moving on to the next one, AB 1914 Davies Resource Family Approval Training. This bill will exempt a resource family member pertaining to foster care that has an active and unrestricted license issued by healing arts boards, including the BRN, from any requirement to complete or show proof of completing CPR or first aid training. So this is on the consent calendar in the Assembly Committee on Human Services. And basically what they're saying is that, this proof doesn't need to be shown by these licensees, these who are licensed by the listed healing arts boards, because that's part of their training. They don't have to necessarily provide, they don't have to provide that proof of completing CPR or first aid training. So
Any questions or comments from the board? I'd like to make a motion to support. Do I have a second?
I do actually have a question. Do we know that all these boards require CPR? We don't require CPR as part of our licensure, right?
Have a specific requirement within the Board of Registered Nursing that requires CPR. However, each one of our pre-licensure nursing programs that start the student through the process does have a requirement for CPR and basic first aid, and that is carried over to the clinical agencies as well. That is part of a clinical requirement that they have to show proof of before getting into a clinical agency. And so that is required through employment and other means, but not necessarily through the Board of Registered Nursing. CPR is considered pre-licensure. Is considered education that is not within the licensing realm, because it also goes out to lay people. The Board of Registered Nursing has jurisdiction over the education that's specific for RNs and for education that occurs after your license as an RN that expands on that knowledge. Basic first aid, basic CPR does not expand on that knowledge, which is why the board does not have any regulatory authority or jurisdiction over that.
And the reason that this regulation is there, that if you're going to become a foster parent, is that what it is? There's a requirement that you have a course in CPR and first aid, is that?
That you show it within 90 days and then you show continuation of that, as what my understanding is. Yes.
I mean, it would seem to me that it would make more sense to show that you'd already done it as part of your work, right? And not necessarily that you're totally exempted, because if you're both, and if you're not doing it as part of your work, then you probably should do it if you haven't been trained on CPR and you're taking in a foster child, I would think.
But then would you want to do a support with amendments, and the amendment being that they have to show that they are current as part of their work?
That's what I would say.
But isn't that already in this language?
Not that I'm able to see. It says that
Exempt a
they
resource.
just have to be licensed.
Right, they have to be an active and they have to be holding an active and unrestricted license issued by the Medical Board of California, Osteopathic Medical Board, the Podiatric Medical Board, Physician Assistant Board, the Board of Registered Nursing, and the Board of Vocational Nursing and Psychiatric Technicians, and the Respiratory Care Board as well.
Yeah, so I don't think that it has a specific, like you have to be current. So that could be something that we would say that you would support with amendment, that it would have to be current as part of your employment.
I'd like to make that motion.
Yeah, let me withdraw my motion. I withdraw my motion, previous motion from the floor, and then go ahead, Mary.
And I will, oh, and I'll like to do the new one. I would like to make a motion that we support this legislation as long as demonstration of proof of current CPR can be provided.
I'll second it.
Certification, I guess.
This is Reza. This is a little bit foreign to me, but I'm not quite understanding. We're saying that they have to require proof of current CPR
certification.
Isn't that what's already required under this statute?
That's how I initially took it.
Yes.
It looked like, it sounded to me like you just had to have a license, you know, that you don't have to have current CPR in order to have a license.
Are you saying that they have to show proof that they have a current license or proof that they have current CPR training?
Current CPR training. And
So
most people probably will through their work.
It says, I'm just reading, again, this is, not at the top of my mind, but existing law requires counties as part of the resource family approval process to ensure that resource family applicants complete a minimum of 12 hours of pre-approval caregiver training and that resource families complete 8 hours of annual caregiver training. Existing regulations also require counties to ensure that resource families complete CPR and first aid training within 90 days of approval as a resource family, and that resource families maintain a current CPR and first aid training certificate thereafter. So, okay, so this is saying that under current law, within a certain time frame of being approved to be one of these families, that they have to take the training, that they thereafter have to maintain it current. And so you would require that they just
Demonstrate that they're current. Typical CPR is lasts every 2 years. So it would make that they didn't have to do it within 90 days, but if they could show that they had a current CPR certification, then they would be exempted.
And it says CPR or first aid training.
I think it says and.
Well, I'm reading it here. To complete or show proof of completed CPR or first aid training.
Is that in the bill analysis or is that on the actual bill that's on the website? Because it could have been a typo in the bill analysis that was forwarded out.
It's reading what
the actual bill text.
Yeah, I think we're reading from different parts of the bill. I was saying under current law, they have to show proof of CPR and first aid training. Under the amendment, the language that would be added is that you're exempt from providing CPR or first aid training. So you, under the amendment, if you're licensed, you'd be exempt from providing both.
Mm-hmm.
Not real clear.
I still think it would be reasonable if people, I'm more comfortable personally with people's ability to do first aid from the training they had as their entry into the profession. But and we know that CPR, it's important that you do it on a regular basis to maintain current, and the rules change. So I would say if they had a current CPR certification, then they would be exempt from that and the first aid piece.
And Mary, for healthcare professionals, it's typically a combination. They're not able to do an either or So when you do like American Heart Association, it's a combo first aid and CPR, and then you do the extra leveling, which is specific for a healthcare provider.
The support, if amended, to require demonstration of proof of current CPR certification in order to be exempt from these requirements. Right?
Yeah.
Anyone?
I seconded it. All right, we can move on.
Thank you. Right. Going on to AB 2055, Assemblyman Lowe's bill, Controlled Substances Cures Database. This bill will, as of April 1st, 2023, transfer the responsibility for administration of the Cures database from the Department of Justice to the department specified by the governor. So the intent here is that at the moment, Cures remains housed under the DOJ because it evolved from early tools established primarily for law enforcement investigations. However, experts and policymakers now recognize that combating prescription drug abuse should be approached through a health-oriented lens rather than through criminal prosecution. And so that is what's the intent behind this. And it is scheduled for hearing coming up shortly on March 29th in the Assembly Committee on Business and Professions.
Is there going to be an expectation that that new agency will be identified before the bill is passed?
My understanding is that this will fall under the pharmacy board, but I haven't received confirmation in writing of that. But when we did discuss this within the legislative roundtable that we do through the DCA, pharmacy board is the one that it's being looked at, which would make complete sense.
So, as far as the author, I did reach out to them, and what they say in their fact sheet is that over the next year, discussions regarding how and when to achieve a successful rehoming of cures are anticipated to ensure that, it remains a robust tool for health practitioners, regulators, and so on. So that's going to happen, those discussions over the next year or so.
I would like to make a motion to watch.
That I do have concerns about taking it away. I completely understand that it is more of a public health issue, but I do worry about taking it away from
DOJ.
law enforcement, even though, there certainly is a strong argument against it.
Okay.
Be clear, DOJ is where we get kind of our reporting and stuff for. I think the law enforcement involvement would still be there if needed. Is that your understanding as well, Gurpreet, that it doesn't remove it from any fining, any enforcement, any prosecution? It just removes it from the Department of Justice managing it to another board or bureau, correct?
Right. That will still be ongoing. The law enforcement, that'll still continue. That will still be allowed to be done, and because that's going to be ongoing as well.
Thank you.
Yeah, all processes remain the same. It's just who houses it and oversees it and manages it.
Yeah. All right. Moving on then to the next one, which is AB 2107, Assemblyman Flora, Department of Consumer Affairs. This was an earlier placeholder bill listed under direct impact. Now this has language which will allow any adult who has received appropriate training and is acting under the authority of the CLIA waiver director and ordering physician to carry out in the specific case of rapid antigen testing performed under a CLIA waiver both the collection of anterior nasal swabs where the individual is being tested is unable to self-swab, and performance of the rapid antigen test. So this was initially for COVID-19 testing, but in yesterday's amendment, the author has removed that reference and that sole purpose for this in this provision. So There is another provision which also authorizes a person licensed as a clinical molecular biologist to engage in or to supervise others engaged in molecular biology related to diagnosis of human genetic abnormalities within the specialty of genetics, specifically molecular biology within the specialty of microbiology. So the intent here is that in order to avoid, these incredibly long turnaround time, this turnaround time for test results during a spike in case counts, there must be a workforce that can easily transition from their core work of genetic testing to infectious disease testing as the need arises. So this is currently in the Assembly Committee on Business and Professions.
Any questions or comments from the board? I would like to make a motion to support. Thank you.
Right, thank you so much. Moving on then now to AB 2123, Assemblyman Villapadua's bill. This is bringing healthcare into Communities Act of 2023. It establishes the Bringing Healthcare into Communities program to be administered by the California Housing Finance Agency to provide housing grants to specified health professionals, including nurse practitioners and certified nurse midwives, to be used for mortgage payments for permanent residents in a health professional shortage area as specified under the bill. A health professional would be eligible for a grant for up to 5 years, and the bill would make its provisions operative, of course, upon appropriation by the legislature. So the intent now here for this one is to seek to increase the number of health professionals in areas designated as federal health professional shortage areas by providing housing grants to specified health professionals to be used for mortgage payments. And it's seeking to ensure health professionals become a part of the communities that they serve, and will ensure rural residents have access to healthcare that they need and that they deserve. So it is in the Assembly Committee on Health at this time.
Is there any opposition to this?
Let me quickly make sure I'm current on any bill analysis that I might have been posted recently. Nothing yet. So I don't have that information just at the moment.
I don't know a lot of specifics about this particular bill, but it would definitely help the Central Valley, the rural areas. We have a shortage. Well, there's not really a shortage, but we can't retain people to stay in these areas. So this would really help us retain some of those professionals in our areas, in our rural areas.
It is supported by the California Association of Orthodontists, so that is an association that is supporting this bill.
I can see the value in a bill like this, but I wonder, who we're displacing when we try to prioritize, healthcare. I wonder if it is the role of the Board of Registered Nursing to take a position on a bill like this. It feels maybe a little bit like mission creep, even though, personally, I support a bill like this.
Questions?
I think that isn't there such a program like for teachers? They buy a house, they get some assistance or some stipends. I'm looking at this in this regard, and again in the Central Valley, it's the lack of nurses that are not staying. They come here, go to school, they leave. Maybe they reside here, but they stay for a while, then they leave for higher wages and better opportunities. But I think if we offered this, hopefully that they will stay, make this their home.
Well, and especially now that we're going to have all these new 104 NPs that can practice independently, right? I'd make a motion.
It doesn't say registered nurses. It's not to nurses. It just says nurse practitioners, nurse midwives.
mentioned with the 104 NPs, it does follow that one. Yeah, just not to basic, not basic, I'm a basic RN, but not to RNs that don't have the advanced practice.
I mean, I just wonder, are we then displacing people like childcare providers, like, laborers? I mean, that's kind of my concern. We're basically saying, healthcare workers are more important than some other low paid workers. So that is what my concern is.
Is there anything in the language that says that the nurse practitioner or midwife has to be working in that area? They get this grant? And they could have the house there, doesn't mean they're working there.
Yeah, it is. It's basically incentivizing them to live and practice in such an area. So that's what will make them eligible for those payments, to qualify for those grants.
So if they get the grant, they would have to agree to stay a certain amount of years in that area?
Exactly. Oh, I'm not sure. I don't see any language pertaining to how long they might have to stay, but it's regarding for them to be living in that in a shortage area.
I thought it said for 5 years.
Oh, I might have been. I'm sorry. I think so. I did go over that. Eligible for the grant for up to 5 years.
They have the grant for 5 years, but does that mean that they have to live there? You can get the house and you can get the grant, but do you have to be there?
It says to be used for mortgage payments for a permanent residence. I don't see anything else that spells it out in more detail than that, but in my mind, permanent residence means you have to live there.
Okay, thank you.
If we're going to support a bill like this, we have to insist that people be living and working in the area and not living in a house in Tracy, but commuting into San Francisco.
Support with amendments.
I think that makes sense, Tricia. I mean, I live in
Yeah.
San Diego and I work in Sacramento. So I would not qualify for this. My permanent residence is in San Diego and my employment is in Sacramento. And way that we are in the world, that makes sense with being able to telehealth, telecommute, et cetera. That does make sense. So support with amendments.
Yeah, I'd be willing to support with amendments. And I mean, really, to get back to, what Imelda talked about is there really are areas in our state that, need to attract, lower income workers with higher value housing. So.
Yeah. I will second your motion, Tricia.
All right, moving on.
All right, moving on. I'm sorry, I think I pulled the amendment.
This is Reza.
Yeah.
I apologize for the interruption. So we just discussed 2123. Can you tell me, just for sake of my notes, what was the bill before this? You were talking about molecular biology and things.
Yeah. That was 2107, AB 2107.
Got it. Thank you very much. Sorry about that.
Yeah, no worries at all. I just wanted to clarify the motion was to amend, and the amendment being sought was
that the person.
If healthcare workers were going to be eligible for this money, they needed to live in the house and work in the county.
All right, moving on to the last one. That is Senate Bill 1475. That's the Glazer's bill, blood banks collection. This one will authorize blood collection at a blood bank when a physician or surgeon is not physically present, if the medical director and their medical advisory committee approve, and if the employee placed in charge is a registered nurse. The bill would authorize the registered nurse placed in charge to be physically present or available via telehealth. The bill would exempt a blood bank from the requirement to obtain verbal or written consent from a patient for the use of telehealth. So the intent for this bill is that California is the only state to require on-site RNs where whole blood collections are performed, fully qualified and appropriately trained staff, qualified donors for donation, perform phlebotomy and manage reactions at blood drives across the nation without the presence of a RN and without impact to donor safety, as demonstrated by nationwide hemovigilance data. So they want California to align with that and increase access really for communities because of a shortage that what they say is a substantial, serious shortage that is ongoing at this time. So it is scheduled for hearing on April 6th in the Senate Committee on Health.
I would support anything that increases blood donations. There really is a significant shortage. It's a standard across the country.
We initially opposed this bill because it didn't designate an on-site RN when someone was giving blood. I believe this is the bill.
Yes, Dolores, that's the bill. Originally, the board took an opposed position because no licensed personnel needs to be on site. So they could draw blood, be there, do all that kind of stuff. If an emergency occurred, if any kind of complications occurred, there would not be a licensed RN on staff or physician. They would only be there via a telehealth. And as we know, and I believe as the board discussed, that we license people that live in New York to get a license in California to be able to provide telehealth services in California, and they're physically located in New York. So there is no way for that RN that is monitoring through telehealth to provide emergency hands-on services there. So that was the reason that the board opposed previously. And so that is the one that you're referring to, Dolores.
I know I used to work for Miles Laboratory, which is a blood collection spot. And we had reactions all the time that I would have to intervene for. So.
But why would we be the only state that requires this?
I don't know, good lobbying efforts? I have no idea. But I think in the interest of public safety, to me, it makes sense to have an RN present, physically present, while the blood collection was being done.
That's making the assumption that the RN's available, right? Because if we are, again, say we're in Central Valley, and there's not that many, right?
But the RN would be available. Right now, they would be available. What this is saying is they can be available through telehealth, which, as Lori just said, they could be off in New York with a California license, doing this by camera.
If that's the standard in all the other states, Dolores, I'm not sure why we would need to be different, because a huge health issue, public health issue, is the lack of blood.
I understand that. But I think we owe it to our public here in California to do it safely, to help manage. If something goes wrong, it goes wrong all the time. I've seen it. There are reactions that need interventions. Maybe we're the only state that is really considering this thoroughly. I can't speak about the other states, Mary. All I know is I have done work like this, and it's important that an RN be present.
So would you amend it to say the RN had to be present, support it, but RN present, and not the telehealth? Take telehealth out. Sounds like
the other thing that I would ask for the board. I'm sorry, Mary. I didn't mean to cut you off.
It sounds like the synopsis that right now there's a requirement for a physician, right? This would be moving.
I believe so. Yeah. So some of the amendments that could be considered is the one that you suggested, Mary, to address Dolores's concern, was to have everything to be support with the amendment that an RN be on site. The other thing is what we can talk about is what we just had put through to the other indirect bill, which was the seizure one. The seizure medication at school, that is administered on an emergency basis as long as 911 has been called and that there is an emergency follow-up. That could be the consideration, that if something has been in place that this could be handled. You may even consider that in a location, excuse me, in a location that that maybe the telehealth could be offered by an RN if you're associated with a facility and you're within 5 minutes of that facility or something to that effect. Because I'm hearing you, Mary, where you're like, this is a dire public health need. We need blood. We need to be able to get blood to people in these rural areas. Maybe there are amendments that you guys could consider. And I think in the law right now, it does require an RN to be on site. I think that was one of the things that our board had talked about previously. I'm going to go ahead and pull that up and see if I can get that for you. Because this might just be removing that, having to have an RN on site. But yeah,
It does remove that. It does remove that.
What was that, Capri?
It does, Lori, it does remove that requirement that a registered nurse has to be physically present.
Yeah, so I think current law has that RN on site. And so to support or oppose with amendment, whatever the board decides to do, that if that amendment is putting that RN back on site. But you could also consider other provisions. And that's what I wanted to kind of bring to you guys' attention, because there were other provisions written in when that seizure bill was passed for schools. I know nurses, bedside nurses oppose that vehemently. I know that the school nurses oppose that vehemently as well, because they didn't want a non-trained person to administer medication rectally to a student. And that was a big deal. But they put provisions around that, which were able to provide that emergency service and maintain safety. And so if the board I do see that we have a strong opposition to this, not wanting to go forward without an RN being on site. I see, and that's with our board president. I also see with our board vice president that she's able to say, no, this is a huge public need. We need more blood. We need more blood in rural areas. So instead of kind of combating, if there's some way that we can do like an amendment that would put some provisions that would say associate with an RN could be there through telehealth if they're associated with a facility that's within 5 miles, or an RN could be there via telehealth if they have a transfer agreement or an emergency provision set into place if they're within 5 minutes. Whatever it is that would make someone feel safe to have that service and still be able to provide that emergency care. And so just to put those out as possible options for you guys to consider to go forward and look at making a motion.
Dolores, would you be able to support that if it was within, a lot of times we have things that someone needs to be available within whatever, 30 minutes. I don't know if saying the exact number of miles is going to be, but that they would need to be able to respond in person within X amount of time.
But in a rural area, they may not be able to.
Well, that would be the rule. Then they would need to be in person, either in person or able to respond within 30 minutes. Is what I think that would be very reasonable.
And just point out, I just received an email from Vince Chi. He is consulting on the Assembly Committee on Business and Professions, and you might be listening, Vince, if you are. And it's he just said that as an FYI, this bill would codify the current practice under the CDPH emergency waiver. It's been happening without an RN on site since the start of the pandemic, and CDPH hasn't reported any adverse events beyond what was happening pre-pandemic. So
I think that's very valuable information.
What if a nurse is doing this by telehealth and she's supervising more than one facility, maybe 2, maybe 3? Is that safe?
That you put in, Dolores, that says that the nurse that is doing this telehealth service be solely focused on this and not managing other telehealth calls or areas during the same time. That could be an amendment.
Well, the language here allows the medical director and the medical advisory committee to approve if the employee placed in charge is a registered nurse. So it's at the discretion of the medical director of the blood bank there, whether they're going to put an RN in there. At least that's how I'm interpreting reading this. When the physician surgeon is not physically present, which most of the time they're not, if the medical director or the medical advisor committee approve, and if the employee place is a registered nurse, it's up to them to even decide whether the registered nurse is going to be in there. We'd have to rewrite the whole thing here. And I don't see any point in having a registered nurse via telehealth. They should be there.
Yeah, I believe so too. They should be there.
Because something has to be done. The question is, what's happened there that they need a licensed person to be there? You need to be there, not come 5 minutes, but 5 minutes.
Or even a nation away.
No, it's ridiculous.
They need to be there.
That's right.
So maybe we can be known as the safest state to give blood.
There doesn't have to be a physician or surgeon there. And the medical director decides if they're even going to put a registered nurse there. At least the way I'm interpreting what I'm reading here.
I think it's really important to pay attention to the fact that this is exactly how it's been for the last 2 years with no untoward situations. So
I'm not sure. I would like to know how that's reported.
Right.
Because I know this was years ago now, but when I dealt with reactions, there was some paperwork, but it was very brief. And you briefly said what you did to mitigate it. I'm not quite sure how that's reported out or how that information is collected.
This is a reaction to donating blood, Dolores?
Yeah, they faint. Low blood sugar, yes. Sometimes that happens. If you go to blood banks, they have that on hand. They have snacks that they can give you, or they'll call. I mean, I can see a call to EMS that definitely warrants a report, and maybe that is reportable. But we would have patients, well, they're not really patients because they're not inpatients, but clients that would faint.
And there's some people that give blood so frequently. I worry about those patients also. And are they taking a history of these patients? Do they have hypertension? What other stuff is going on with them? There's people that, like to give blood, they're helping other people in that.
I mean, I'm willing to let this go, but I think that we might be creating a conceptual problem when we're faced with a real one.
I understand, Mary, what you're saying, but in reality, things happen to people when they give blood. Even just sticking a needle in them, they're ready to pass out.
I have a question. When the blood mobiles come around, do they have a registered nurse? I think they're mostly like MAs, like LVNs. I'm not sure if they even have a registered nurse on site in the mobile, vans.
They don't.
In law, it's required that they have an RN on site.
Yeah, that's a good question, but I believe they have an RN.
I'm
RN when they came to my daughter's high school years ago.
And in the van, but they don't have it in the blood bank itself.
Well, I'm a regular donor. I give 5 times a year, and I'm in blood banks a lot, and there's always a registered nurse on site, and there's always someone who is fainting or has just fainted.
It happens. I'm telling you guys,
it has not been me, but there's always someone with an ice pack on their head, on their arm. And especially as they do the platelets. Things do go wrong.
We always have orange juice on hand. We have the cold packs. We have snacks. Yes, it happens.
And the nurse, the RN that is overseeing this Red Cross site, she's hopping. She's busy the whole time. It's a busy site. I mean, it's a big one and lots of people are there, but it is a little reassuring to have a nurse on site. I've fortunately never had a need for it, but I can see the benefit of it. And I'm surprised other states don't do it because it, you know, as I said, I do see something every time I go.
I did want to point out that the American Red Cross does support this bill, and they have an official support position on this bill.
The Red Cross, is that what you said?
That's correct, Betty. Yeah, the American Red Cross. Yeah.
I mean, I'm willing to bet that they would want to have a nurse there, but there's times when they can't, and that means they can't have the blood bank open to be able to take donations.
Correct. And just to address that point, you know, the author says that there are thousands of blood donations across the state that are lost each year as a result of blood drives canceled at the last minute due to RN staffing challenges. So that has also that's something that's been occurring as well. So, and that the COVID pandemic is not expected to subside for several years, and other virus. You know, there are other viruses that are considered a pandemic threat. So basically, the state needs to be agile and prepared to have blood available reasonably and safely collected via a telehealth oversight by an RN.
Well, I do think there is a way to balance this. I mean, we could support with amendments and say that a nurse would really have to be available within some appropriate amount of time. I'm not the person to dictate what the time is, but maybe some of you who have had some real life experience might suggest that.
They need to be on site.
Help is needed immediately.
Right. It's not 5 minutes away. It's not 10 minutes away. If something happens, it has to
I
be
mean,
done.
what if that nurse gets stuck in traffic?
Please.
You know,
Mhm.
I would like to make a motion to oppose, to continue our stand or continue our position on the board to oppose.
Jovita seconds.
That's the end of all the bills here. Thank you so much, board members. Any questions that you might have in addition?
So at
I'd be
this
happy to answer.
point, we'll have to move out to public comment, and then after public comment, we will go ahead and take a vote on all these bills, and then immediately following that, we'll take a lunch break. One real quick thing, I know that with public comment, typically we limit that to 2 minutes per agenda item. As this is right now, it is set as multiple items that we're taking one comment. So if a person has 2 or 3 bills that they wanted to speak on, I would ask that our public let us know that in advance so that we can adjust the time accordingly to address that. And so we had a first from Dolores and a second from Jovita. Is that correct on this last bill?
Yes.
Thank you.
This is Reza. As Lori said, I think next would be public comment and then taking a vote on the bills and then lunch. I'm not sure if there's any interest in a break at this time. It's been 3.5 hours.
Yeah, we had just mentioned that we were going to do a lunch break.
Be fine,
Take the
probably.
vote.
What do you guys?
I mean, it's possible that there may be substantial public comment and then that may prompt further board member discussion and then
Yeah, I'm
so
with
this
you.
may or may not be a quick thing.
That is correct. Sorry.
I think we should do lunch now.
Yeah.
Public comment. The vote won't take long and we can do lunch.
So Dolores, do you want to open up to public comment and see
Yes.
how many are there?
Sure.
And then make a decision? Because if there's like 50 people there, that would not make sense to delay a lunch.
Pete, can you read through all the proposed positions before public comment?
Really, for each bill, Imelda?
Yeah, the proposed positions.
Yes, absolutely.
Thank you.
So going to the first one, I believe AB 646 was I might have missed the end of that discussion. I
Support with
didn't catch that position.
amendments.
Okay, got it. And then AB 1662 is a support. I'm sorry, a motion to oppose on 1662. No motion on AB 1756. AB 1996 wasn't opposed.
But support for 1996. Did I get that?
Oh, you're correct. Supported, and then Trisha, second.
Reza, can you do the support and oppose and
I'm sorry,
motions?
I'm
I
going
know
through-
that Gurpreet was struggling with the internet connectivity and getting on, and so if you could help her through that process, that would be great.
No worries at all. Yeah, I have that listed within my here. So it's I'm just scrolling down. That's taking me time, and apologize. So Reza, absolutely, if you want to do this.
Sure. I'll read what I had. Anyone else, if you had something different, please let me know. AB 2188 was a support. AB 2397 support. AB 2600 oppose. AB 2637 oppose. AB 2684 watch. SB 889 support. SB 1031 support. SB 1237 support. SB 1365 support. SB 1375 support. AB 1810 support. AB 1914 support if amended to require demonstration of proof of current CPR certification in order to be exempt. AB 2055 watch. AB 2107 support. AB 2123 support if amended to require that the healthcare worker both live and work in the shortage area. And SB 1475 oppose. Hopefully that lines up with what everyone else had.
What I had.
Okay, so board moderator, can you open it up to public comment, please?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time is expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." And if you do speak on more than one bill, I will extend your time limit. No worries.
Thank you. And then board moderator, can you let us know how many people are waiting for public comment before we begin?
Right now, yes, right now, just one. Saskia Kim would like to make a comment. 1 second, please.
Going into public comment.
We're not?
We're not?
No, I'm sorry. I thought the idea was to see how many people respond and decide based on that whether we need a break or whether, I mean, if the public comment.
Right now, there's 2.
Why don't we go ahead and just wrap this up?
So we'll open it up to Saskia and then follow it up with Catherine Hughes.
Oh, we have 3 now. 4.
And George Carrillo, Monica Miller. There's 4.
Yes. Is that good? Are we ready?
Go ahead.
Board president said yes, Mark. Let's go.
Okay. Sorry. Saskia Kim would like to make a comment. 1 second, please. Go ahead, Saskia.
Thank you. Thank you for the time. Saskia Kim of the California Nurses Association. Thank you for the time today. I just want to comment quickly on 3 bills, AB 1996, AB 2637, and SB 1475. We submitted our letters on these bills, and as I think noted earlier, these are included in your meeting materials under the additional information link. First, CNA is opposed AB 1996 by Assemblymember Cooley. This appears to start with the underlying assumption that regulations are bad. We disagree. Regulations are protections which safeguard the health and safety of workers, patients, and communities in California. I know you discussed existing law on this issue earlier, so I just want to offer a few quick clarifications. First, there were 2 areas of existing law that weren't mentioned that already address this issue. First, existing law already allows any person to petition a state agency to request the adoption, amendment, or repeal of a regulation. So that would include any regulation that the petitioner believes is duplicative, overlapping, inconsistent, or out of date. And second, existing law also gives the legislature the authority to direct OAL to initiate a priority review of any regulations that fail to meet the standards outlined in the APA. And that existing review process sets forth standards and procedures for engaging the legislature, state agencies, and the public. And then second, as noted earlier, OAL already ensures that proposed regulations are not duplicative, overlapping, or inconsistent when it reviews regulations. And this process is for every regulation that's proposed, so any later regulation that comes along would be captured during this review. OAL would look at that proposed regulation and compare it to any existing regulation, so there isn't a hole there. And despite all these existing processes and protections, AB 1996, we believe, would require the board and other state agencies to divert scarce resources away from your public protection mandate and instead direct those resources to a redundant bureaucratic process created by the bill. The next bill is AB 2637 by Assemblymember Rubio. CNA is opposed to this bill because it would deregulate nursing education and would instead allow nursing schools themselves to regulate their own enrollment and clinical curriculum. This deregulation of minimum nursing education standards directly conflicts with the board's public protection mandate. The bill would permit the unchecked growth of nursing programs, and that's especially troubling because it's coming at a time when there's been a rapid expansion of private nursing programs. In California, enrollment at private nursing programs is increasing, and graduates of private programs are increasingly making up a larger share of nursing school graduates. So, for example, only 4 private schools graduate 26.9% of all NCLEX test takers in 2020 through 2021, and that's an increase from 21% of all NCLEX test takers in 2017-2018. And California's experience is also playing out nationally. A nationwide study which included California found a 402% increase in for-profit nursing programs across the country over a recent 10-year period. That same study found the number of for-profit nursing program graduates increased 1,305% over the same period. And as you know, public nursing schools programs are much less costly than private nursing programs. Many nursing students have to take out burdensome loans to fund their private nursing education, which can saddle them with significant debt. And that can create an occupational barrier that threatens the ability of students from disadvantaged backgrounds to enter the middle-class workforce. We're also opposed to AB 2637's proposed increase in simulation. We're opposed to the substitution of clinical learning with actual patients for learning in a high-fidelity simulation laboratory beyond what's currently allowed. We believe that doing so threatens safe patient care by increasing the risk of reduced clinical competency. The most sophisticated mannequin cannot replicate the human response to nursing care or indicate the subtle changes that can occur during the course of an illness. We believe students should be educated so that they are able to develop skills and critical thinking ability rather than simply being trained in tasks. So CNA supports the use of direct patient care clinical experiences to ensure that nurses are ready to provide safe patient care when they graduate. And that protection of the public requires, in our view, direct patient care experience. We'd also note that NCLEX scores have gone down during the pandemic, and the most recent annual schools report also noted that 97% of schools substituted simulation for clinical experiences during the pandemic. Although we don't know if there's a causal relationship between these two facts, there's arguably a correlation worth noting. And finally, the board has already directed and is working on determining a minimum number of direct patient care clinical hours rather than increasing the percentage of allowed simulations. The board's already addressing that issue. Finally, CNA opposes SB 1475. This is the bill that you just talked about that deletes existing law's requirement that blood banks have an RN physically present. This bill also would ignore your public protection mandate. CNA opposes it because we believe the presence of an RN is necessary to assess and address complications when a blood donor suffers an adverse health event. The data shows that California actually has a greater incidence of complications than other states, likely related to our donating demographics, which are often young donors. And this demonstrates the need for the presence of an RN. Nurses are very concerned that patient safety will be put at risk by this change. A transfusion medicine article looking at blood donor complications after whole blood donation stated that there are 15 million whole blood donations per year in the United States, and 1/3 of the donors develop one or more adverse events. Moreover, the collection of whole blood from healthy donors is only one procedure performed in blood bank settings. Other procedures that involve a potential for greater risk include apheresis, during which a particular blood component is obtained from a donor and separated out for collection, and the remaining blood is then returned to the donor at the end of the procedure. So for all these reasons, we request that the board vote to oppose AB 1996, AB 2637, and SB 1475. Thank you very much for the time.
Thank you. Kathy Hughes would like to make a comment. 1 second, please.
I'm a registered nurse and the executive director of the Nurse Alliance of SEIU California. And while SEIU California has not taken an official position on AB 1996, I am going to go back to my e-board and recommend an opposed position. We don't believe that that we need this. We think the BRN already reviews their regulations, and while we appreciate the idea of being transparent, we don't believe that this is necessary. Regarding AB 2637, I also am going to recommend an opposed position on this, agreeing with all of the comments mentioned by the previous speaker, by EO Melby, and by the board members, as we all agree to oppose this bill. And then regarding SB 1475, SEIU is on record as opposing this bill, and for all of the reasons previously mentioned, acknowledging that we need to address blood donations and how to increase that while maintaining public safety at the same time. As the previous speaker mentioned, there is more than just blood donations being done, and some of these procedures are more complicated than others. And so there should be, if we really need to address increasing blood donations, we need to look at some other options for that continue to protect public safety. Thanks.
Thank you. George Carrillo would like to make a comment. 1 second, please. Go ahead, George.
And thank you for the board for allowing me to make a comment. I've been a registered nurse for 12 years and licensed in the state of California since 2015 and currently reside in Arizona. I'm a frequent traveler nurse to California, and I would just like to make a public comment on SB 1475, and I would support the opposition to this bill. I think it's very important that we do have nurses present at sites where patients can experience complications. I would also just like to note that if we do oppose a bill like this and we're saying that a nurse should be present, I think it's also important that we, and I don't know how the board operates in California and what guidance is given to employers that are employing nurses, but I think it's important, especially now since COVID, where many nurses are being deployed to other work sites or other areas of practice that they may be unfamiliar with, that there is a way to support nurses in knowing what is in their scope of practice. So perhaps they're not acting as a licensed independent practitioner in these sites, vis-a-vis giving their own orders of how to care for a patient who is experiencing any type of complication due to blood donation, apheresis, etc. But that they would know that they're acting under some sort of standing order that has been provided by the medical director of such sites, so as to avoid any potential litigations should those types of actions be taken against the nurse serving in this type of role.
Thank you.
Thank you.
I'm sorry. Thank you. Monica Miller would like to make a comment. 1 second, please. Go ahead, Ms. Miller.
Hearing me today. Monica Miller, representing the California Association of Nurse Anesthetists, and we'd like to thank you for your moving to a support position on our sponsored bill, SB 889. We look forward to continuing conversations with Executive Officer Melby as well as her staff. Thank you and have a good day.
Thank you. Board President Trujillo, there are no other public requests for comment. Would you like me to close this window?
All right, we'll take it to a vote. So we have the motions and the positions stated previous to public comment. Dolores Trujillo votes yes. Vice President Mary Fagan.
I guess I vote yes.
Elizabeth Woods. Imelda Ceja Bukowitz.
Imelda, yes.
Jovita Dominguez.
Yes.
Susan Naranjo.
Susan Naranjo, yes.
And Trisha Nguyen. All right.
Real quick, this is Reza. I should have chimed in, but all of those votes are presumably as to all of the motions that were made. So, you know, you have an opportunity if you wish to express a no vote or a contrary vote to pull that out, and even if the motion is going to pass, identify yourself as having opposed it if you choose. But with kind of the way this was structured, I think it's presumed that your votes were a yes as to all of those positions that were just taken. So hope that's clear.
Well, probably should have said that before the voting.
Sorry about that.
That's okay. Mary?
I will change my support all of them except for the opposed to SB, what is it, 1475.
Right.
Dolores, since the vote is complete and we've got that marked that Mary changed that to be more specific, appreciate that. Thank you, Mary. We would recess
till
the board
1:30.
till 1:30, but at 1:30 we would not come back to the board. We would come back to committees. Is that correct?
Yes.
And then we will start with the nurse practice committee. Okay, perfect.
One other clarification on that. This is Reza. So the final item on the board's agenda is a closed session for disciplinary items, but I believe we are going to the committee meetings, and then after the committees are concluded, coming back into the board meetings strictly to go into closed session for discipline. So for those members of the public who are listening, we're that's how we're ordering things. But at the end of the day, when we come back to the board meeting, it's only for that closed session, which public members would not be, I'm sorry, members of the public would not be allowed to view anyways. So that's all.
I just have a question about coming back for the meetings. Are we go to this team meetings closed session? We're not staying.
No,
not
no, you'll come back to the WebEx.
Oh, okay.
You can leave the WebEx open and just mute your mic and turn off your camera if you want, or you can just come right back into this WebEx. The Teams meeting that you got, that's for the closed session that's going to be later on after all the committees are done.
Okay, thank you.
And what time are we coming back?
1:30.
Okay, sounds good.